We are going back. We are in the throes of our offer to purchase and contract in Unit 10. And where we left each other the other day, we were just finishing up kind of talking about our due diligence, our earnest money. Remember, the first provision of our offer to purchase and contract, the first 2.5 pages is terms and definitions. So we're still defining things. And we had defined the earnest money and the due diligence. And now we were looking at what we do with that money. So now that we've defined, and let's just do a little recap. Both due diligence and earnest money are negotiable. Okay, both are negotiable. Whatever the buyer's willing to offer and the seller's willing to accept. The due diligence is made directly from the buyer to the seller. The buyer pays the seller a due diligence fee, and what they're paying them for is the right to terminate. And the right to terminate for what reason? For any reason or no reason. So they could have a real legitimate reason, or I'm not kidding, they literally could wake up the next day and say, nah, I'm not going to buy this house. So they have this period of time, this window of opportunity to terminate for any reason or no reason. The earnest money is a check made out to the escrow agent. It sits in the trust account. It shows the buyer's good faith. It shows the seller that the buyer is serious. It shows the seller that the buyer has a little bit of money in the bank, that they can afford to put money in the bank, in the trust account, so maybe they can afford to buy my house. If we make it to closing, both due diligence and earnest money will be credited to the buyer. So what we mean by that, if we look at, we're back on page 1 of our offer to purchase and contract. We had of our purchase price of $100,000. Let's say we negotiate $500 in due diligence and $500 in earnest money. That means down here at the bottom, the buyer has a balance of $99,000. They have prepaid $1,000, if you will. Think of these almost like down payments. They've put down $1,000. So now all they have to come up with is $99,000, which we're told some or all may be paid with the proceeds of a new loan. If we don't make it to closing, if we terminate, what happens? Well, the seller almost always gets to keep the due diligence fee, no matter when the buyer terminates, in due diligence or outside of due diligence. Remember, if the buyer terminates within due diligence, that's what they paid for. They paid for that right to terminate. If the buyer terminates within due diligence, the seller keeps the due diligence fee, the buyer gets their earnest money back. If we terminate after due diligence, the seller gets both the due diligence and the earnest money fee. Technically, the buyer's not considered in breach until after due diligence, because while we're in due diligence, that's their right to terminate. So they're not breaching the contract until after due diligence, and their consequences of breach, the seller gets the due diligence and the seller gets the earnest money. We're going to see, we have a provision at the end of our contract about what happens if either party breaches. You guys remember back in Unit 9, we talked about something called liquidated damages. We're going to learn in just a bit that the seller's liquidated damages are the due diligence fee and the earnest money. So what are the buyer's consequences of breach? These negotiated amounts. So buyers may offer, $5. Listing agents, we need to have a conversation with our sellers. If the buyer terminates the day before closing, are you okay with receiving $5? And that's what we need to make sure. That's why it's a negotiable amount. What if the buyer just never shows up to settlement? The seller's only going to get the due diligence and the earnest money. And again, when we get to the end, we'll look at that provision, and it actually says the seller's due diligence and earnest money are their sole and exclusive remedy, which means the seller can't sue the buyer. So they need to be comfortable with this due diligence and earnest money. Y'all think about it. If the buyer terminates the day before closing, the day before settlement, hasn't the seller made arrangements to live somewhere else? Maybe they have a contract on another house, or maybe they've signed a year lease. And now all of a sudden they're finding out that they can't sell their house because the buyer terminated, or just not yet, not tomorrow, right? And they got to put it back on the market and go through that process all over again. So the buyer, the seller needs to be comfortable with these amounts. And that's why they're completely negotiable. The rest of this on this page, earnest money, there's a loan assumption, seller financing. We'll talk a little bit about that when we get to our financing units. If it's a new construction, you'll have a building deposit. I don't ever know of a situation where you're going to have every single one of these lines filled in. But the way this is designed, this line on top is the agreed upon purchase price minus all these lines in the middle to come to the new balance for the buyer. So what questions do we have so far on due diligence, earnest money? Question came in if you have to fill in one of these for your exam. No, you do not. But remember, the highlighted, what you're looking at highlighted, what you see in your book in Unit 10, could be good candidates for test questions. So could you get a test question on due diligence? You betcha. Questions on earnest money or due diligence? Why would what? So about the additional earnest money, is this what you're asking about? It's completely negotiable. So maybe I pay you X amount of earnest money now, and I pay you X amount of earnest money, not you. Maybe I put in X amount of earnest money now, and I put in X amount of earnest money later. Maybe I offer you 500 and you want 1,000. And I say, well, I have 500 now, and I'll have 500 more next week. So the 500 now would be initial earnest money. The 500 next week would be additional earnest money. So this just gives us some flexibility here. And you will note our additional earnest money is also a time being of the essence, which means the due date for the additional earnest money is a drop dead date. Presumably, most of the times when we're putting down the additional earnest money, we're closer to closing. And the last thing we want to do is delay closing, waiting on, additional earnest money to come in. Additional earnest money can only be paid in readily available funds. Additional earnest money can't be a bank check, a personal check, because if I get it a week before closing, we don't want to delay closing waiting on this thing to clear, right? So there's a couple more rules there with additional. Yeah, Tara, it looks like you guys use that as a negotiation tool to let the seller know you were really, really serious. So they like to see that. You could have 500 and 500, for example. How long is due diligence? It's completely negotiable. To the seller, time equals money, right? So if you want a long due diligence, you better be prepared to put down some more money. For the buyer's agent, or for the buyer, we need to make sure that we have enough time to get their inspections done, to get the home appraised, to get through the first round of underwriting. We'll talk about the lender process in units 14 and 15. So buyer's agents, once you start working with lenders, once you work with them a couple times, you learn about how long they need, given unusual circumstances, of course. But if your buyer's using a lender you've never worked with before, when you're writing this contract up, pick up the phone and call that lender and say, hey, about how much time do you need for due diligence? How much time do you need to get the appraisal ordered back? How much, what's your average turnaround time? Sometimes what I'm hearing now, because, buyers are desperate, and desperate times call for desperate measures. And I'm hearing some buyers agents is kind of a crapshoot. It's back to, are you ready to drain your savings account and jump on a plane with me and go to Vegas this weekend, right? What's your risk tolerance? Some buyers are presenting an offer with 1 week due diligence, and then they're crossing their fingers with a hope and a prayer that the seller will give them an extension. So they're asking for 1 week to get under contract. And then once they're under contract, they're hoping they can renegotiate. And we're going to see in just a second, the seller is under no obligation to grant an extension. So that's why it's kind of a crapshoot. It's the risk some buyers are willing to take. I've heard people that put down more money are likely to have their offer accepted instead of someone who does not put a lot down. Putting yourself in the seller's shoes. Absolutely. We're seeing due diligence and earnest money in some cases up in the 5 digits. 5 digits. Giving the seller $20,000 and putting down $30,000 in earnest money. Desperate buyers, desperate times right now. And again, I can't look at the buyer and say, this is what you should do. I need to be looking at the buyer and say, what are you comfortable with? Are you comfortable with possibly losing $20,000? I can't answer that for you. Different risk levels. It's not me that's determining what my buyer's risk level is. But if my buyer wants to put down $50,000 in earnest money and due diligence, it is my job to make sure that they understand what's on the line. It's my job to make sure that they understand their risk. Let's see, would you go over what goes to the seller immediately and what goes to a trust account? I may not be understanding your question, but we only have to pay whatever the agreed upon amount is. Is that what you're asking me? That's all the buyer has to pay is whatever we agree.
Maybe that means the check that goes to escrow versus the check that goes directly to the seller.
Oh, it's completely negotiable. So maybe you offer 50,000 earnest money and 5,000 due diligence, right? It's whatever the buyer is willing to offer and the seller is willing to accept. It doesn't have to be the same amount. It's
But one
competitive
goes
out
into
there.
escrow and one goes right.
I'm sorry?
They don't both go to the same place.
Correct.
One check is made out. The earnest money goes to the seller, right? And
Correct.
due diligence goes to escrow.
Correct. Nope. Here it is. Due diligence fee made payable and delivered to the seller. Earnest money made payable and delivered to the escrow agent. It's a negotiation tool. And a lot of the times, the amount of due diligence and earnest money is reflective of the market. 5 years ago, 20,000 due diligence was absolutely unheard of. Today, not so much. 12 years ago, when the housing market crashed, times were rough for sellers 12 years ago. We're actually going to talk about the housing market crash when we get to 14 and 15. 12 years ago, buyers were offering $50 in due diligence and $50 in earnest money. Sellers didn't see an offer after being on the market for 6 months. They were thrilled to see $50 due diligence and $50 earnest money. So a lot of the times the amounts are reflective of the market. That's why there is no formula. The formula for the amounts are whatever the buyer is willing to offer and the seller is willing to accept. Smart dad. Yeah, I got my license in 08, which is when all this started, the housing market crash. I did not get into sales in 08 though. I just got my license. We'll talk about that housing market crash. Okay, due diligence and earnest money. Any other questions? And remember, you have the definitions for both. Here's our definition for earnest money. Paragraph 23, we'll see that at the end. That's our remedies for breach. So we'll kind of revisit this again. And then here's your definitions for due diligence fee, and the due diligence period. Okay. Good on due diligence and earnest money for now? For now? Okay. Still on the first provision, that is terms and definitions. First 2.5 pages, we're just defining stuff. So now we need to define, there's something called settlement and there's something called closing, and there is a difference. Confession time. We talk about going to closing all the time. I'm going to meet my buyers at closing. I have closing today. My sellers are going to closing. Anybody ever bought a house, sold a house? You were told you were going to closing. Y'all ready for confession? The truth is in all my years, I've never attended closing. What we attend, what we do with our clients is referred to as settlement. Every single one of us in this industry refer to it as closing, and every single one of us is wrong. Because technically what we do is settlement. Settlement is when we go to the attorney's office, the attorney gathers signatures, they collect the money from the buyer, possibly the seller, if the seller has to pay any money. We're going to talk more about the contract to closing process in Unit 21. But settlement is what we attend with the attorney. Settlement is what your clients attend and what you will attend with your clients. The settlement date is a negotiable date. Usually there's a period of a week or two between due diligence and settlement. Again, all completely negotiable. Once we leave the attorney's office, once the attorney has all the documents signed and they have the money from the buyer or the seller, and the seller if necessary, then the attorney performs closing. Closing happens after we leave. And closing is defined, there's a 4-step process. Step 1 is settlement, which we just did. Step 2 is the completion of a satisfactory title update. So the attorney has done the preliminary, the thorough title search when we went under contract. They did the thorough title search. They found all liens. They found any encumbrances. They found any kinks in the chain. Remember, we talked about the chain of conveyance in Unit 5. The attorney, now that we've had settlement, the attorney is going to do one more quick title search just to make sure nothing happened from when they did their thorough title search. And upon satisfactory completion, the attorney will, at closing, offer their opinion to the title insurance company. So the buyer doesn't get their title insurance policy until they get the opinion of title from the attorney. So we leave the attorney's office. The attorney does one more quick title update. The closing attorney receipts of any necessary funds. So they're going to collect the money from the lender. You can't buy this house without money from the lender. And then the very last act, the last step, the last thing to happen is we're going to take the buyer's brand new deed and we're going to record it at the county courthouse. Then and only then is it a done deal. So the last act, the very last thing to happen is to record the new deed. If there's a lender, then we got the deed of trust, also known as the mortgage. Only after the new deed is recorded should buyers be getting keys, should buyers be getting access to the property. The seller doesn't get paid until the new deed is recorded. You and I don't get paid until the new deed is recorded. You will get an email from the paralegal that says, we are on record. That's your notice to turn around and go back to the attorney's office and get your check. It's a done deal then and only then. So settlement, the attorney's starting to gather signatures and money. Closing is the finalization of settlement. I guarantee once you guys get your license and you get out in the real world, you're going to call settlement closing. I promise you. For your tests, you need to know there's a difference. Questions on settlement versus closing? The last word we're defining is special assessments. Let's see, question came in, buyers can't move in until recorded. That's right, because it's not theirs until that new deed is on record. And you probably have a story, maybe even you, where you got your keys when you left the attorney's office. What's the contract say? It's not the buyer's property until that new deed is recorded. All sorts of things could go wrong if you move in before that deed is recorded. And typically, we work really hard for settlement and closing to happen on the same day. Most attorneys don't schedule settlement after like 3 o'clock. So that gives them time to do what they need to do and get that deed unrecorded before 5. All the counties I'm familiar with, triad counties and surrounding counties, we do e-recording now. So it's as simple as hitting a button and then waiting for confirmation. It used to be, before the e-world, that attorneys had couriers that had to go to the courthouse once or twice a day and stand in line and wait to get that deed recorded. Does that not sound like the worst job ever? And things happen in between the attorney's office and the courthouse, right? Like, what if our little courier got in an accident? Or what if our courier drove off into the sunset with deeds on the front seat of their car and said, take this job and shove it, right? Things happen back in the day. Today, things can still happen. Doesn't the internet go down sometimes? Doesn't Spectrum go out sometimes? That's why we need to wait for that confirmation. But more often than not, we settle and record on the same day. Again, buyers should not be getting access to the property until it's theirs. You may have a story. Put it off to the side until after this class, because what's the contract say? Other questions on that? Special assessments. We talked about special assessments. You could either have special assessments from a governmental authority. So maybe they're putting a special assessment on a neighborhood to hook a neighborhood up to public sewer or to install sidewalks. You could also have a special assessment for HOA. So maybe they're repaving the parking lot, for example. Right now, we're just defining special assessments. Later in the contract, we're going to talk about whose responsibility payment of special assessment is. Again, you guys, the first 2.5 pages is terms and definitions, just defining things. So I think these are good pages for you guys to look at, in addition to the rest of the highlighted. Second provision is our fixtures and exclusions. We talked about fixtures back in Unit 2. We saw this very list of fixtures. Remember, if the seller plans to take anything, that's fine. We either need to take it down before we market the property, or if they insist on leaving it up, we need to notify all potential buyers that this fixture does not convey. This fixture will not be here when you get your keys. If the seller is going to take any fixtures, we have a place here that we can exclude them. So grandma's antique chandelier, need to make sure that it is in the offer to purchase and contract. Remember our parole evidence rule. If it doesn't make it into the contract, then it's not, it doesn't count. So make sure any fixtures that are going to go are listed here. I have a place if there's any items that are leased or not owned. So for example, security systems, if it's not the seller's, then it's not theirs to convey. So those would be excluded as well. Then we have a provision about personal property. If the seller agrees to leave the refrigerator, we need to put it in here. Fixtures are meant to stay, personal property is meant to go. If either is going to do the opposite of their intent, we need to make sure it gets in the offer and purchase and contract. Guys, please just don't put refrigerator. Be specific. You know, stainless steel, 2-door, Whirlpool. Sometimes when you got a model number on, like when you open the doors, you got a model number inside the door. If you can get a model number, that's good. There have been cases in the past where somebody has just put refrigerator. That's it, refrigerator. Buyer moves in, gets their brand new keys to their new house and moves in. And in the kitchen is a 2-shelf dorm room fridge. Did the seller do what they were contractually obligated to do? Did they leave a refrigerator? Yeah. Do we have a happy buyer? Probably not. So be specific. Don't leave anything up to interpretation. You know how people can be. You guys know how petty people can be. So don't leave anything up to interpretation. If your buyer wants the fridge, be specific. Spell out specifically what fridge they want. Questions on fixtures or personal property? Provisions 4, 5, and 6 are all about the buyer. So buyer's agents, these should be good provisions for you to point out to your buyers as these pertain to them. 4 is about the buyer's due diligence process that starts with a big red warning. The buyer is strongly encouraged to conduct due diligence during the due diligence period. If the buyer is not satisfied with the results or progress of buyer's due diligence, buyer should terminate this contract prior to the expiration of the due diligence period unless they can obtain a written extension. But please note, all bold, seller is not obligated to grant an extension. So that's what we were talking about a few minutes ago, taking this crapshoot of getting a week just to get under contract and then asking the seller for more time. The seller doesn't have to grant you more due diligence time. So that's a risk, and the buyer's got to be willing to take that risk. If the seller grants you more time, they may or may not want more due diligence money. It's all negotiable. Questions or comments on that? Part of the buyer's due diligence, this provision explains the due diligence process to the buyer. And as we've been saying, the longest part of the contract to closing process is the loan. So if your buyer intends to get a loan, we need to get going on that. Like, you go under contract, you do your little happy dance, and then you immediately send the contract to the lender. Get the lender working on their end, because it's going to take them the longest. Guys, remember, loan approval is not contingent on buying this home. If we find out after due diligence that the buyer doesn't get loan approval, they are in breach, they will have to terminate, and they will lose their earnest money. Them buying this home is not contingent on getting a loan. We also then have property investigation. Here's a whole laundry list of things that the buyer should consider investigating as part of their due diligence. Remember, this is their opportunity to learn as much about the property as they possibly can. Encourage your buyer to have a home inspection. For the most part, I'm sure there's some loan program exceptions, but for the most part, buyers aren't required to get a home inspection. I don't know why they wouldn't. The home inspector's job, these things kind of get doom and gloom, right? The home inspector's job is to walk through the house and find all the problems with it. There's absolutely nothing positive in a home inspection report. This is broke, this isn't working, this needs to be fixed. It's pretty sad. But the buyer needs that information. They need to know as many of the problems as they can, right? To decide, now knowing what I know. Review of documents. If we're in an HOA, we're going to want to help them get the covenants, bylaws, all the rules and regulations of the HOA. Homeowners insurance. Unit 13 is dedicated to homeowners insurance, but we got to get that secured during due diligence. Not all people or properties are easily insurable. So if we find out that their home insurance monthly amount is going to be more than the lender approves, that is going to tip them out of their range, they're not going to get approval, and we're not going to be able to close. Bottom line, if I have to terminate for my buyer, I'd rather do so within due diligence. So the least I can do is get their earnest money back. I don't want to find out that they can't afford home insurance right before settlement. If the buyer's getting a loan, an appraisal is required, period, end of story. The lender will require an appraisal. We'll talk about appraisals. If it's a cash buyer, it's optional. They don't have to get an appraisal. We mentioned the survey, any zoning and government regulations, flood hazard, utilities. Who are your utility providers? Streets, are they public or private streets? Are there any special assessments, fuel tanks? Please understand this list of property investigation is not inclusive, which means if my buyer wants to inspect something or investigate something that's not on this list, my answer is okie doke, let's do it. Because remember, if it's important to my buyer, then it's important to me. And if my buyer says, I want to have this tested, can we do it? I'm not going to say, no, you don't need to do that. And it's not mentioned in the contract. So why are you worrying about that? My buyer says, can we get this tested? I'm going to say, you betcha, let's do it. Guys, I'm not the one buying this house. Who is it for me to say what they should or should not do? Right? Caveat emptor, buyer beware. The buyer takes on the responsibility of learning about the property. And when they hire you, you agree to take on that responsibility with them. So let's see, I got a couple questions in the chat. Let me go back. What are terms for earnest money being returned to the buyer? The buyer will get their earnest money back if they terminate within due diligence. So the buyer will get their earnest money back if we terminate within due diligence. When you have to renegotiate a due diligence period, do you have to write a new contract? I have an amendment. I have an amendment to amend the contract. What do we say an amendment does? Change. I can see your mouths move. Yep. So an amendment changes. So I got an amendment we can use if we renegotiate anything. Is it better for a buyer to be pre-approved? We're going to talk about pre-approval in units 14 and 15, but yes, y'all don't show property until the buyer's been pre-approved by the lender, until they've talked to a lender and got a figure. Please, please don't waste your time, your energy, your gas, please, until you see that pre-approval letter. Again, we'll talk about pre-approval versus pre-qualification when we get to financing. Okay. During the buyer's due diligence property, if they have another home that they have to sell or lease, this is not a contingency, but if I have to sell a house before I can buy yours, then I need to, and as it tells me, I should try to close on my other property prior to the end of that due diligence period. Make sure that it's done. If I find out, if the buyer finds out after due diligence that my other home isn't going to close, I have to terminate and I'm in breach. And if I am in breach after due diligence, I lose my earnest money. Remember, you guys, there are no contingencies. However, the parties can agree to add a contingency. Anything is negotiable. Once the buyer has all their inspections and investigations done, we can ask the seller for repairs. Do your head one way or the other. Is the seller under any obligation to do a repair? Do they have to fit? Do they have to change a light bulb? No, they are under no obligation. We can always ask. The buyer can always ask. The worst they can say is no, right? If the seller says, no, I'm not doing anything, I'm not even changing that light bulb, the buyer has a decision to make. Do I want to move forward with, or do I want to terminate this transaction now knowing what I know? The parties agree Here it is. The property is being sold in its current condition. If if the seller agrees to do anything, then I have a form that amends this one sentence. If the seller agrees to do any repairs, then we use a form that amends that one sentence and is reflective of any repairs that the seller may agree to do. Again, what I'm seeing in this market is buyers are desperate and they're just trying to get anything under contract. They're putting down, $20,000 in due diligence, thinking that means the seller is going to do repairs. And the seller's laughing the whole way to the bank with their $20,000 check. Repair request comes along and they go, no, I'm not fixing anything. And the buyer's saying that's not fair. Well, that's the terms of the contract. Again, you guys, the buyer's not reading the contract. They have no idea what the terms are. That's why they have me and you to help them explain this, to help them understand this, to help them realize their risk. Just because you put $20,000 due diligence down does not mean the seller has to agree to change a light bulb. Are you with me? Does that make sense? Do I have questions? Buyer's obligation to repair damage. We talked about this when we were looking at our consequential damages, our money damages in Unit 9. What this is saying is that any damage to the property is on the buyer. So if the buyer's home inspector damages the property, even if the buyer terminates, this repair obligation shall survive any termination. So even if the buyer terminates, they're still responsible for damaging the property. They can't terminate it and get done with it. Buyer and seller hold each other harmless, indemnify, they hold each other harmless from loss, damages, claims, etc. Buyer's right to terminate. Buyer shall have the right to terminate this contract. Here it is again, for any reason or no reason. All they have to do is give written notice to the seller during the due diligence period. Time being of the essence. If buyer timely delivers his contract, terminated, then the earnest money deposit shall be refunded to the buyer. The buyer doesn't have to tell the seller why they're terminating. All they have to do is provide written notice of termination. And we have pre-printed termination forms. They provide us with all these pre-printed forms, so we're not tempted to draft. I cannot draft a termination form. I'm not an attorney, so they provide us with these. And then the last provision under the buyer's due diligence is big. It's important. That's why it's all in uppercase and all bold. Closing shall constitute acceptance of the property in its then existing condition unless provisions are made otherwise in writing. The buyer needs to understand that when they sign at settlement, they are agreeing to take the property exactly how it is. We're going to talk a little bit more. We'll see in here about the final walkthrough. This one little sentence right here is why the final walkthrough is so important. The buyer needs to see the property as close to settlement as they can. I do my final walkthrough on my way, to the attorney's office. So as close to settlement as you possibly can, because the buyer needs to know what they're signing. Because when they sign, they're agreeing to take this property exactly how it is. So what if you go to the final walkthrough and the home's a mess? What if the seller moved out the day before? They take down their posters and you find a bunch of holes in the wall, right? They take down their pictures and they leave a bunch of trash and the house is a mess. The buyer has two choices. They either sign and accept the property how it is, or they don't. If they go to the attorney's office and sign, they're taking the property with the holes, with the trash. If they don't sign, hopefully we can get the seller to repair it. The seller, that could be a breach for the seller. But that's why the final walkthrough is so important. Questions on that? Congratulations, Mr. and Mrs. Buyer. The home and all its problems are now yours. Here are your keys. Okay. Buyer has representations they have to make to the seller. These are things that they're telling the seller. The seller should be able to rely on this information when deciding if they want to enter into a contract with this buyer. So this information needs to be complete. And one of the biggest questions the seller has is, how are they going to buy my house? What's their funds to complete the purchase? So the buyer needs to represent if they're a cash buyer, that's what this first check mark is, or if they're getting a loan. And what's the loan information? The buyer needs to represent if they have other property to sell or lease. This is not a contingency. The buyer is just representing that they have another home to sell or lease. They're letting the seller know. The buyer has to represent that they've received or have not received the RPODs and the MOG. We looked at these back in Unit 8. So the buyer has to say, yes, I've received these disclosures, or no, I have not. Remember, if they've not received it, this could be a reason for the buyer to terminate, the right to terminate, get all their monies back, including due diligence. This could be one case where the seller could lose the due diligence. Listing agents, don't let your buyer terminate because your seller didn't complete this form. Have them do it. Stand over them. Make them do it. The 6% provision is buyer obligations. What are the things that the buyers are responsible for? We just defined special assessments back on page 3. We're going to see in just a second that the seller is responsible for any special assessments that are confirmed prior to settlement. The buyer is responsible for any special assessments that are confirmed after settlement. So maybe there's an HOA proposal. Maybe they're discussing it. It's still proposed. It's not been confirmed yet. So the buyer's going to take subject to all special assessments following that are confirmed following settlement. The buyer's responsible for all of their due diligence, inspections, and investigations. They're responsible for paying for the home inspection, the appraisal, the title search. Questions on the buyers? Provisions 7 and 8 are about the sellers. So listing agents, make sure your sellers see what their responsibility is. And just like the buyer had representations to the seller also has representations to the buyer. Again, the buyer should be able to rely on this information when deciding if they want to enter into a contract with this seller. So the seller has to represent how long they've owned the property. If somebody's owned the property for less than a year, they're probably an investor or a flipper. Some loan programs, loan packages care about that, some don't. So that's why the seller has to disclose their ownership. The property was built prior to, there's our magic year of 1978. If so, the seller has to provide the lead-based paint hazard addendum. If it's in an HOA, the seller represents that. Getting the HOA information to the buyer the best that they can. This same list shows up in the listing agreement. So we can have this conversation with our sellers when we list the property. Have them gather the HOA information to help provide the buyer. And then we're going to list who the association is. The dues are X amount per month, per quarter, per year, however that HOA is set up. The seller has obligations. They have to provide title. They have to pay off all their liens. Let's see. Do you have a case where the seller refused to give back the due diligence even if breached? I haven't. What do you do at this point? They need to take it to court. If the seller's refusing, the buyer can sue the seller for compensatory damages. If the seller leaves garbage, trash, all the property, would this be a reason to consider a breach where the buyer could get their earnest money back? Due diligence, reading this on page 291, could be. That would be up for an attorney, for a judge to decide. I mean, what kind of trash are we talking about here? Are we talking about a piece of paper, or are we talking about a house full of trash? You with me? Guys, bottom line, if two parties can't agree, the judge will decide for them. I can't decide for them, right? So if the two parties can't agree, I'm not buying this house because all the trash, the seller says, what trash? We can try to get them to come together, but ultimately the judge will help them decide. Seller access to property. Seller has to allow the buyer and their inspectors onto the property to do their due diligence. The seller can't deny the home inspector, the appraiser. The seller has to allow these people in so the buyer can do their due diligence. And the access to property is where it also talks about the final walkthrough. The buyer or the seller can't deny the buyer doing their final walkthrough. You know, again, maybe when you showed your buyer this house, it was vacant and it's been vacant the whole time. Still do the final walkthrough. What if somebody came in last night and trashed it, right? What if you've never seen this home vacant? Definitely do the final walkthrough. If the seller moves out the day before settlement, you're going to want to see this home. Remember, you guys, when you're in somebody else's home, you can't touch their personal stuff. So if there's a picture on this wall, what if there's a big hole behind this picture? The whole reason this picture is here is to hide the hole. And I move out today, you see it before, you know, the day before closing. So that's why the final walkthrough is so important. The buyer needs to know what they're signing. Removal of seller's property. Seller shall remove personal property, garbage and debris from the property. Sometimes sellers think they're leaving gifts. And what it comes down to is they don't want to mess with it. They don't want to move it. For example, the grill. In several cases, it comes down to loading up the truck and the seller doesn't want to mess with the grill. And they say, oh, well, I'll leave it for the new buyer. And you know what the buyer most often says? My grill's better than yours. If I wanted your grill, I would have asked for it. Get it out of here. Make sure your sellers aren't leaving gifts. You found a hole in a staged property? That's not good.
Actually, after I saw the home, it was staged by the real estate company. And they had pictures on the wall, the little furniture inside. And then when we closed and moved in, we saw the hole on the wall that was behind one of the pictures. Actually.
Isn't that something? So that picture was strategically placed. It was staged, if you will. One thing, removal of seller's property, again, that final walkthrough, y'all make sure you're poking your head up in the attic, down in the basement, make sure there's no personal property there as well. I had buyers a couple years ago, and when we were looking at the property, it was like the pull down stairs in the hallway, you know, for the attic, you put in the stairs kind of fold down. And we poked our head up in the attic. We saw a bunch of stuff in the attic. Well, the sellers are still living there. So, okay, no big deal. Final walkthrough, the home's vacant. We poke our head up in the attic again. All that stuff is still up in the attic. It hadn't been touched from when we saw it, when we were looking at it. And I called the listing agent. I said, what about the stuff in the attic? And she said, well, that's not theirs. I said, well, who is it? Whose is it? Guys, these people had lived in that house for 6 years and had never once looked in the attic. The stuff in the attic was from the previous owner. explain to me how you live in a home for 6 years and you never once poke your head up in the attic. And this particular buyer was actually a very good girlfriend of mine. And I said, man, there might be treasures up there. Are you sure you don't want to, you sure you don't want to buy? And she said, no, I got my own junk to worry about. I don't want to worry about somebody else's junk. I said, all right. So I called the listing agent back. I said, yeah, this stuff, it's got to go. So the listing agent and the sellers showed up to the attorney's office a little sweaty. They had been working hard because, again, this was my girlfriend. So we went and had lunch or breakfast, you know, on our way to the attorney's office. And they showed up a little sweaty because they had been getting junk out of the attic. How do you, I'd been in that home 3 times in my life and I'd seen the attic twice. How did they live there for 6 years? Moral of this story, poke your head up in the attic every once in a while, especially before you buy or sell a house. Is that not unbelievable? Scary, yes. Ooh, somebody got a piece. Let's see, a couple questions and then we're going to go to break. Bear with me. If the appraiser appraises the home less than what the property is listed for, can the loan deny the loan? I'm going to talk about that in financing, so hang on to that for just a minute. Different markets, different things. Yep. I mean, all sellers, some sellers have more pride than others. Let's put it that way. Million, I'm with you, Matt. Yeah, I wanted my friend to keep it so we could go through it and see what she had, but she wanted to deal with her own stuff and she didn't want to mess with somebody else's. So I lost, but that's okay. I want one buying this house. So bottom line, this is why the final walkthrough is important. The buyer, once they sign, again, when they bought that house 6 years ago, the stuff was in the attic. So once they signed, that stuff became their stuff. By the way, all that stuff was out on the curb waiting on waiting on trash pickup. All right, let's take our break. We come back, we keep going through our offer to purchase and contract. Let's take attendance. We talked about buyers. We've talked about sellers. We're still talking about sellers, excuse me. Removal of seller's property, affidavit, indemnification agreement. The seller has to swear that they don't have any liens that we don't know about, that the attorney couldn't find in the title search. So for example, our mechanics liens, any person who's performed or furnished labor, services, or material that could file a lien within 120 days. So the seller has to say this affidavit saying this can't happen, this won't happen. This is probably the most important. The seller's biggest responsibility is to provide good title legal access. So sellers shall execute and deliver a general warranty deed, and we talked about that in Unit 5, recordable form, which conveys fee simple marketable title without exception to mechanics liens, free from other liens, encumbrances, those that could be found in a survey, except for ad valorem taxes, easements, covenants, unviolated covenants, and any of these other such liens or encumbrances or defects that may be assumed. Property must have legal access to public right of way. That paragraph pretty much sums up our first 6 units, doesn't it? Whole bunch of words in that paragraph that you didn't know, presumably didn't know when we first got started. So this paragraph, that's why we spend the time that we did in the first 6 units to make sure that we're all good with these words, because it's in the offer to purchase and contract that we use every single day. Deeds, fees, and taxes. Seller pays for preparation of deed. We talked about that when we talked about seller net. The seller pays for deed prep. Seller also pays for excise taxes. So we talked about that in Unit 5. We'll see this again when we get to 21. And then we need to list who the deed is to be made out to. Again, this is the legal names of all the parties, all the buyers that are going to be on this brand new deed. And if there's a lender involved, they'll probably require their spouses as well. So we're going to put all the legal names in here that need to be on the deed. If the seller agrees to pay any of the buyer's closing costs, that's a negotiable item. The seller maybe agrees to pay some of it, maybe they don't. What we're seeing right now in this market is that they're not, just a big fat zero. But again, that pendulum is going to come back, and that's going to be a point of negotiations where the seller is going to pay some of the buyer's closing costs. Any negotiated repairs, any repairs that the seller agrees to. Remember, they don't have to agree to anything, but if they do, they need to be done in a good and workmanlike manner. And the buyer has the right to verify them once complete before settlement. So when the seller says, okay, these agreed upon repairs are done, the buyer has the right to verify. Maybe they send their home inspector back out there for a lesser fee. Maybe they go put their eye on it themselves. But the point is that they have the right to verify it before they sign. Seller's breach of contract. This is what paragraph 23 is for now. So again, we'll see this in just a second. Paragraph 23 was just added last July. So it's a new provision for us. So we'll see it in just a second. Questions on any of the seller's responsibilities or obligations to the buyer? Okay. Prorations, we talked a little bit about prorations. We'll see this more in Unit 21. As a matter of fact, in Unit 21, we get to do the proration math. So we have that to look forward to. But this just tells it that there's certain things that may be prorated. Remember, if we're prorating something, we're just taking a shared expense and making it fair. If the buyer's buying the house this year, it's not fair for either party to pay the full year's taxes. You shouldn't have to pay the full year's taxes if you didn't own the property for the whole year. We all in agreement with that? It's not fair, is it? So we're going to prorate that expense. So we define that. Again, we're going to do that math in Unit 21. So we'll see proration again. Our risk of loss. It's still the seller's property until the new deed is recorded. Thus, The seller must maintain homeowner's insurance until closing. And listing agents, we need to have that conversation with our sellers. Make sure they understand. Just because you're under contract doesn't mean that they can cancel their homeowners. If the house burns down while we're under contract, that risk of loss is still on the seller because it's still their property. What if the house burns down while we're under contract? Well, this is where it gets interesting. The buyer has choices. If, for example, the house burns down while we're under contract, the buyer may terminate the contract. And if they do so, they'll get their earnest money deposit back. Doesn't matter if we're in or out of due diligence. House burns down, buyer's going to get their earnest money back. If the buyer does not terminate this contract, in addition to receiving the property, they're also going to get the proceeds of any insurance claim filed by the seller. So the house burns down. It's not over yet. The buyer has choices. You want to buy this house and get the seller's insurance proceeds to rebuild? Or do you want to terminate, get your earnest money back and move on? Again, you guys, I can't make that decision for the buyers. I will say this. If my buyers look at me and say, what should I do? Or even they don't have to look at me. I'm going to volunteer my opinion. The house we're under contract burns down. I'm going to look at my buyers and I'm going to say, you need to talk to your attorney and you need to talk to the seller's insurance company. You need to get more information before you make the decision if you're going to terminate and move on or not. Isn't that interesting? I always find that so interesting. House burns down. It ain't over. It is not over. Questions or comments on that? Delay in settlement. Y'all, delays just happen. They just happen. They're very, very common. The best thing you can do is tell your people early on to have a plan B. I don't know what's going to cause it to delay. I don't have a crystal ball. But what I do know is delays are common. They just happen. And to best protect yourself, have a plan B. What are you going to do if closing gets delayed? Where are you going to live that night or those 2 nights? There's not much more that makes me more nervous than a buyer showing up at the attorney's office in the U-Haul truck. Because if they're showing up in the U-Haul truck, where are they going next? Or where do they think they're going next? So please, please, please have them have a plan B in place. Built into our contract is a 7-day delay. Please listen to me. This was a change effective July 1st of last year, 2021. If you get your hand on a contract, on any other contract, it's going to say 14 days. Your book probably says 14 days. You're always going to be tested on the current information. So today, anytime you see 14 days, cross it out and write 7. Today, there's a 7-day delay in the offer to purchase and contract. So here's the deal. When it comes to delay, you have a delaying party and a non-delaying party. One party's causing the delay, the other party's not. Probably one of the more common reasons for delay is we haven't got loan approval yet. We haven't got the final thumbs up from the attorney. Maybe we need another day, maybe we need another 2. In that situation, the buyer's the delaying party, the seller's the non-delaying party. And because this is built into our contract, if we're delayed because of failure to get loan approval, the seller has no choice but to sit still and be patient for 7 days. There's nothing they can do but just hang out, fingers crossed, hope this is going to work out. If on day 8, we still haven't closed, then the non-delaying party may terminate this contract. And the other party suffers any consequences of breach that are spelled out in paragraph 23. So the non-delaying party, they just sit and be patient, fingers crossed, and hope that we get loan approval, hope that whatever's causing this delay works it out. Questions on that? Possession. Possession includes all means when the buyer can get keys, codes, security codes, garage door openers, electronic devices, etc. Shall be delivered upon when? Closing. The buyer should not be getting access to the property until that new deed is recorded. We may have a case to do a buyer possession before closing or seller possession after closing. We'll actually talk about these forms, these situations in just a bit. Somebody says sister bought a property, closing got delayed, typical. They let him in, so probably what they agreed to do was a buyer possession before closing. Sellers don't have to do that, but yep, sounds to me, just from what you're saying, that's what they agreed to do. Again, the parties can agree to whatever they want to. Yeah, did I hear something? Did I hear a question? No, I'm just hearing things. Great. The possession, you'll notice yeah, so 292, again, your book still says 14 days. Anywhere you see 14 days, just change that to 7. You'll always be tested on what the current forms say. You may have noticed scattered throughout our contract as we were looking, when we have a need to use an addenda, it tells us. So it tells us when to use the FHA VA financing addenda. It tells us when to use a lead-based paint addenda. Now we have this nice little handy dandy checklist to make sure we have all applicable addenda attached to this offer when we're presenting it. So use this as that. Make sure you have. I don't think I've ever been in a situation where we haven't had at least one addenda. So using addenda, one or the other, plural, singular, are very, very common. If you don't provide them, if you don't attach them, then they don't count. So it's really important, if one's applicable, you have to include it. You have to add it to your offer to purchase and contract. So you can use this as a little checklist. Some other stuff not highlighted because I'll let you look at it if you want. I do want to point this out just to make sure we're all clear. Contract shall be binding upon and shall in order the benefit of the buyer and the seller and their respective heirs. When do heirs kick in? After the individual passes away. So death is an out only when you're negotiating the offer. Death is not an out when you're under contract. Okay, death is only an out when you're negotiating the offer. And here's our new provision, the remedies for breach. And they broke it down, breach for the buyer, breach for the seller. So again, if the buyer breaches, we are outside, we're after due diligence. And the breach for the buyer is the seller's liquidated damages. Liquidated damages are those money damages that we talked about in Unit 9 that we agreed to at the time when we enter into the contract. And for the seller, their liquidated damages are the earnest money deposit and the due diligence fee. And the contract says that their liquidated damages are the seller's sole and exclusive remedy for the buyer breach. So if the buyer terminates for any reason after due diligence, they are in breach. The seller gets the earnest money and the due diligence, and that's it. They cannot sue the buyer. Sole and exclusive remedy. Consequences for seller breach are much harsher than consequences for buyer breach, because the seller is the one that initiated this whole thing to begin with by putting a for sale sign in their front yard. We would never be in this situation if the seller didn't say, I'm selling you my house. You guys with me? So because they initiated it, because they came up with it. You don't see this section in the book? That's correct, because we just got this section in July of 2021. So the book hasn't caught up to it yet. So I think you guys should make a note, paragraph 23. In the event of the buyer breach by seller, and the buyer elects to terminate because of the breach, the seller shall return both the earnest money, the due diligence, and any costs incurred by the buyer in connection to their due diligence period. So what's the money they spent for their home inspection? What's the money they spent for their appraisal, pest inspection, survey? Their compensatory damages. They can prove they spent this money with invoices, with receipts. If the seller's not willing to sit down and write out a check, the buyer sues for compensatory damages. Remember, the buyer can also sue for specific performance. The buyer can sue the seller to make them sell. They can make them perform. Then we have a provision about attorney's fees. Basically, if you're suing, if the contract's pretty clear about what happens if we breach. And if you're unwilling to follow through with the terms of the contracts and I have to sue you, I'll win because the contract says I will. So in addition to me winning, not only do you get to pay your attorney's fees, but you'll get to pay mine too. So let's try not to take this thing to court. That's why we have a contract, trying to keep everybody out of court. That's why sellers and buyers hire me and you, because we understand the terms of the contract. They don't. They are not reading it. Questions on these remedies? Contracts change about once a year, if necessary, which usually they change about once a year. All right, so now we're at the end. Place for the buyer to sign, buyer on the left, seller on the right. I got a place for 2 buyer signature, 2 seller signature. If you have more than 2 buyers or 2 sellers, we have an additional signatures addendum. So we'll look at that in just a second. We add as many signatures as we need for the sellers to convey and their spouses, and as many buyers and their spouses are going to purchase this property. If it's an entity buyer or seller, we have that information. And then here's our wire fraud warning to both. We saw a wire fraud warning to buyer in the buyer's agency agreement, wire fraud warning to seller in the listing agreement, and now we're seeing it to both. Wire fraud got really big, really fast in real estate. Think about the amounts of money exchanging hands in a real estate transaction, in a real estate closing. A couple years ago, it's been a few years now since I've heard this stat, but a couple years ago, the FBI was saying that billions, that's with a B, billions of dollars was intercepted through wire fraud, either never made it to the closing attorney from the buyer, or it never made it to the seller as part of their proceeds. So we need to help make sure that we can protect our buyers and sellers from wire fraud. And the absolute best thing that we can do to protect our buyers and sellers from wire fraud is to look them in the eyeball and say, I will never email you wire transfer instructions. If you get an email from me or the attorney with wire transfer instructions, it's good chance that one of our emails got hacked and the hackers are sending information for their bank account. So if the buyer's going to wire their money into the closing attorney, if the seller wants to receive their money from the closing attorney, they need to go old school, pick up the phone and call the closing attorney and get that wire transfer information over the phone. And the number they're calling is from a number that they independently obtained. Don't call a number from an email. So when it comes to wire transfer, never, ever, ever email wire instructions. Y'all, my Gmail is about as secure as my closet door. Hackers are trained to get into emails. That's what they do for a living. Billions of dollars have been intercepted from real estate transactions. I went to a wire fraud seminar down in Raleigh. It was back in 2019. And it was really interesting. We had the attorneys there. We had the title insurance company there. We had the FBI there. Everybody was there talking to us about it. The FBI stood in front of us and said, hackers are always 2 steps ahead of us. By the time we figure out how we're doing this, they've moved on to the next. They anticipate the FBI catching up with them. Some things you can do to protect yourself. Add your 2-step verification to your email. Add a 2-step verification to your email. So not only do you need a password, but anytime somebody tries to access your email, you get a text too. So it's a 2-step verification. Change passwords. Y'all stop using password 1234. The FBI says, you know, they see password 1234. You know what hackers try first? Password 1234. Don't change your passwords now. I call that a distraction. Wait till after class. But have unique passwords. And I think something else you guys can do to protect your information and your client's information. If you're going to take your laptop and go work at like Panera Bread or Starbucks today, don't get on their public Wi-Fi. Because if you get on Panera's public Wi-Fi, who can access it? The public. The FBI showed us a video of a young lady. She looked perfectly innocent. She was not wearing her I'm a hacker t-shirt. And she went to Panera Bread and she created a Wi-Fi called Panera Bread 1. And within seconds, people from all over Panera Bread were accessing her Wi-Fi. So if you want to work in public, that's great. Do it on your mobile hotspot. Don't do it on a public Wi-Fi. So let's see a couple questions. Typical forms of money, cashier's check, wire transfer. Bottom line, it's got to be readily available funds. Nobody wants to wait between settlement and closing for a personal check to clear the bank. So attorneys won't accept personal checks from the buyers. Oh, Alicia, I'm sorry. It's very, very real. And like I said, it got really big, really fast in real estate. So we need to do what we can to best protect our clients. Guys, there's nothing I can do 100%, but if something happens to one of my clients, the real estate commission is going to look at me and they're just going to say, Julie, what did you do? And I'm going to say, well, I have 2-step verification. I have a unique password. I use my mobile hotspot. I'm going to do my best. These people that are losing money, buyers and sellers that are losing money, it hasn't happened in North Carolina yet, but there are cases in other court cases in other states. And y'all, these people lose hundreds of thousands of dollars from the real estate table. They're going after everybody. They're going after their agent. They're going after the attorney. They're going after every single person involved. Again, no lawsuits in North Carolina yet. Comments on that? Questions? It's unbelievable.
I mean, yeah, the Pentagon, CIA, FBI, I mean, some of the most secure agencies in the world have been hacked dozens of times.
That's right.
So if they get hacked, your email is nothing but a soda can.
That's exactly right. People make it so people can break it. Thank you for that, James. Other questions or comments? Okay. Page 14 is our notice information. Remember, we talked about communicating and how we want to communicate. Well, first we have the sellers and buyers information if we want to communicate that way. But more often what we see is the agent's information, the agent's communication information. So remember we said buyers on the left, sellers on the right. Buyers on the left, sellers on the right. So we have on the left the buyers, the selling firm, the firm working with the buyer. And then we have to identify the role of the selling firm. Is the selling firm acting as a buyer's agent, a seller subagent, or a dual agent. We put the firm's license number, mailing address, and then we identify the individual selling agent and whether or not they're acting as a designated dual agent, license number, contact information. And then we go through that again on the listing side. The listing firm, they're acting as either the seller's agent or the dual agent, firm license, mailing address, individual listing agent acting as the designated dual agent, license number, and contact information. This is the only place that we belong in the offer to purchase and contract. And we are here only of confirmation of agency notice. We are here because you're communicating with me so I can communicate with my client. Questions on this? This is page 14. This is where I identify my firm's role and my role if I'm a designated dual agent. Then the last page is when we're delivering monies. So we go under contract, yay. You're the buyer's agent. You call your buyer, you say, congratulations. When are we going to meet today to get 2 checks? I need a check made out to the escrow agent. I need a check made out to the sellers. Buyer's agent gets the check. Buyer's agent delivers the due diligence to the listing agent. Upon receipt, listing agent acknowledges receipt of the due diligence fee. Then the listing agent takes that due diligence money to the sellers, upon which they sign acknowledgement of receipt. So pretty much anytime that money changes hands, we have to sign receipt. Can we all go ahead and agree that on its way and in your hand are 2 totally different things? Just because they call you and say, oh, I'll drop it off at lunch, don't sign this until it's in your hand, until you actually have touched it and have it in your hand. There have been cases down at the commission where the due diligence money goes missing. And they pull up this form and they see that the listing agent signed acknowledging receipt. And they call the listing agent. She said, yeah, I never got that. Well, you signed that you received it. Well, they told me they drop it off after lunch. In your hand and on its way are 2 totally different things. Everybody good with that? Don't sign it till you got it. And then there's a place for the escrow agent to sign if you have earnest money. So there's that initial and additional earnest money. And that, ladies and gentlemen, is your 15-page offer to purchase and contract. This thing continues to grow. Honestly, we're probably about a revision away from 16 pages. We are not far at all. They keep adding to it. I bought my little condo in 2008. What was that? 14 years ago. In 2008, this thing was 8 pages. No, 6. I bought in 6. I'm sorry. This thing was 8 pages in 2006. We've added 7 pages since 2006. Anytime there's a court case, a lawsuit, we get a new. It's so very important. And you know when it changes, trust me, they'll send you an email, they'll send you the revised form, your broker in charge will have a meeting about it. If you don't know, it's because you got your head buried in the sand. Questions or comments about our offer to purchase and contract? Remember, 287 to 293 list the provisions that you should know. I went through and highlighted those provisions, so make sure you look at those highlights. Starting on page 293, we talk about some commonly used addenda. this in no way, no means are all of the addenda, but these are the ones that we see the most often. The North Carolina Association of Realtors and the North Carolina Bar Association, in addition to providing us with the offer to purchase and contract, they also provide us with these addenda and amendments. I got a couple amendments we're going to look at as well. Remember, I can't draft. So they provide me with these forms to help reduce my temptation to draft. And if you're ever in a situation where a form doesn't apply to your situation, if you don't have a form that applies, then you tell your clients to hire an attorney to draft a form up. A question comes in as a provisional broker who's filling that out. You're just doing it under the direct supervision of your broker in charge. So as a provisional broker, you get to fill in the blanks. You get to fill out the forms, but you're doing it under the careful eye. So an addendum, when you see the word addenda, why don't you tell me in the chat, when you see the word addenda, what does an addenda do? Yep. When you see the word addenda, see the word add. An addenda adds to and becomes part of the offer to purchase and contract. Compare an addenda to an amendment. What does an amendment do? Yep. An amendment changes an already existing agreement. We're under contract, we've already signed, shaken hands on it, whatever. For whatever reason, we decide to go into round 2 of negotiations. If we amend it, we change it. If we have an addenda, we add to it. So what we're going to do now is look at some of the more commonly used addendum on pages 293 to 295. I have these forms available for you guys in Learn, Test, Pass, and we'll look through them pretty quickly. You don't need to study these forms, but you need to have a basic understanding of what they do. I imagine for your test, you'll get a scenario and it's going to say which addenda is applicable. So you don't need to study them. You don't need to go in depth, but you need a basic understanding of what they do. So the first one we have is our FHA VA financing addendum. You don't need to know the numbers. And we add this when your buyer is getting an FHA or a VA loan. We'll talk about the different loan products in units 14 and 15. But if your buyer's getting an FHA or a VA loan, make sure you include the FHA VA financing addendum. And basically what this form does is protect the buyer's earnest money. If the home doesn't appraise, if we find out after due diligence that the home doesn't appraise, this form will allow the buyer to get their earnest money back. In addition, there's a section about a VA loan. VA will require some borrowers to do certain inspections. For example, the VA requires a pest inspection. They require it, mandatory. However, they don't let the buyer pay for it. So the other part of this addenda alerts the sellers that they may be on the hook for paying certain costs. Listing agents, have a conversation with your sellers when they're deciding if they want to accept this offer. Do they have to accept this offer? They say, I'm not paying for somebody else's pest inspection. They have 3 choices, don't they? They can accept it, reject it, or counter it. So FHA VA financing addendum. Another one we have, well, 2, I guess, we just kind of lumped them together. We have a buyer possession before closing and a seller possession after closing. Either the buyer's moving in before the new deed is recorded, or the deed is recorded and the seller's staying. So possession can be negotiable. Anything's negotiable. Bottom line, what we need to understand in these situations, one party is acting as the landlord, the other party is the tenant. One party owns the property, the other party is renting it. Whomever owns it must have homeowner's insurance. Whomever's renting it has to have renter's insurance. This is meant for short-term use only. I'd say anything under 14 days. If you're looking at anything over 14 days, then you're going to have an attorney draft up a lease. Because this form is like a page and a half long. It doesn't cover long-term, but it does address things like, are pets allowed? Who's responsible for lawn care, utilities during this time? So somebody said your sister bought a house. They probably used the buyer possession before closing. That's just my guess.
Julie, I have a question.
Yes, ma'am.
With the buyer possession before closing, say the buyer takes possession before closing and they discover something while they are staying in that property, how would, are they still within their rights to, I guess, cancel the contract or terminate?
As far as problems with the property, this form specifies that basically when they move in, due diligence is over. So they're waiving that if they're moving in.
Okay.
This form also addresses what happens if the buyer moves in before closing and it never closes. So the form addresses that as well. But yeah, if they move in and we're still in due diligence, they're basically, due diligence is over. Okay. Lead-based paint or lead-based paint hazard addendum. We looked at this in Unit 20. This is required on all property. Why don't you guys unmute yourself? Everybody unmute yourself. It's required on residential property built prior to what year?
1978.
1978.
1978. Okay, you guys can mute again. So anytime you have a for sale or for rent on a property built prior to 1978, lead-based paint hazard addenda is required. We looked at that in Unit 20. I think probably the most popular, commonly used addenda is the additional provisions addendum. This addresses provisions that are really common, but they're just not common enough yet for the offer to purchase and contract. They're popular, they're common, but just not good enough, just missing the offer to purchase and contract. So there's several other provisions that we can have. We talked about the buyer putting an expiration date on the offer or putting an expiration date on their offer. If they were going to do that, they can use the additional provisions addendum. So let's say they say by tomorrow at noon. If they put an expiration date on it, that means tomorrow at 12:01, if they don't have acceptance, this offer is dead. This offer is expired, it's terminated. If there's a septic tank, or if it's, if the buyer needs to test to see if the land will support a septic tank, then we have a provision for that. If the property has a current tenant, an existing lease in place, the buyer buys honoring any existing leases. So if there's a tenant, the seller needs to provide the buyer with that tenant's information, with the rental information. If there are any agreed upon repairs or improvements that the buyer wants the seller to consider before we even go under contract. Remember, we might ask for repairs after we're under contract and we've had our home inspection. But if the buyer wants something fixed before we go under contract, then we can include this agreed upon repairs or improvements. Let's say, for example, you're shown a property and the backyard, to go out to the backyard, there's a sliding glass door. And you note in the sliding glass door, there's a little, it looks like a little rock hit it, maybe a lawnmower threw a rock. And there's a little hole in the sliding glass door and it's starting to spider a little bit. Do you really need a home inspector to come in and tell you that that's broke? You can look at that and be like, gee, that's broke. If the buyer's adamant about having, I will not buy this house if that's not fixed, then we can use agreed upon repairs and or improvements. Please understand, this does not negate the buyer's ability to do their investigations once we do get under contract. And once they learn about the property, they can ask for more repairs. They can always ask. There's a mobile home on the property. We got a provision for that. And then if there's a pool or a spa on the property, this is important. An outdoor pool or spa, this is important like today. They've been winterized. Do you know if they work? Don't really know until we have them inspected. So this provision addresses who's going to have it unwinterized, who's going to re-winterize it after it's been inspected. Obviously, we're not using this that much. If it's like August, it's probably hopefully already open. Questions on this one? Another commonly used addendum we have is the Owners Association Disclosure and Addendum. Exempt, E-X-E-M, that should say exempt. Make a note to fix that. We use this form, this discloses if we're in an HOA. And if it's in an HOA that the RPODS is not required, the RPODS is exempt. One of the biggest examples of when the RPODS, the Residential Property Owners Association Disclosure Statement that we talked about in Unit 8, one of the biggest reasons that the RPODS is exempt is new construction. So if you're new construction and you're in an HOA, you don't have the RPODS, but the buyer still deserves to know information about the HOA. So that's what that form does. It addresses just HOA information when the RPODS is exempt. I just added this, sorry. I just realized like Monday that I didn't have this in my PowerPoint. So if you're looking at my PowerPoints and Learn Test Pass, it's a bonus slide, bonus material. Another commonly used addenda is the vacation rental addendum. We don't use this much here in Winston-Salem. I mean, Winston-Salem is lovely, but people aren't vacationing here. Go down to the coast, go up to the mountains. If you're already at the coast or the mountains, you very well may deal with vacation rentals. You're going to want to get more training on that, get more knowledge, and you'll probably be a lot more familiar with the vacation rental addendum. So anything that's subject to vacation rentals, I got a form for that. Possibly an Airbnb. There's certain rules for vacation rental. I'm not overly familiar with those rules, but what qualifies as a vacation property? So if an Airbnb falls under those qualifications. We got the short sale addendum. Now we're going to talk about short sales and financing. So we'll actually probably look at this form in financing. But what we need to understand right now, a short sale is a situation where the seller owes more than what they can sell the property for. They're underwater. They can't sell the property and pay off all their debt. So they may qualify for a short sale. And again, we'll talk more about it in 14 and 15. In North Carolina, short sales, potential short sales, a material fact. So as a buyer's agent, you know, you're showing your buyer a potential short sale. If they want to go under contract, we include the short sale addendum. This provides outs for the buyer. And this form creates a contingency. And basically what that contingency says is, if I don't get approval from all lien holders, then I can't sell my house. So what are the conditions of selling my house? What's the contingency? I got to get all lien holders basically to agree to sell at a loss. You got to get the lien holders to agree to accept less than what they're owed. If they don't, then I can't sell. That's the contingency. Again, we'll look at this in financing because I think this form does a good job of defining what a short sale is, talking about the risks involved, etc. And then the last one we're going to talk about for right now, well, kind of, addenda is the backup contract addenda. If you're using a backup contract addenda, it's because you're presenting an offer on a property that's already under contract. There's an acceptable offer, seller's under contract. The buyer still wants a chance. With the backup contract addenda, we're still going to negotiate all the terms of the offer like we always do. We're going to negotiate the sales price, due diligence, earnest money, all that. And upon acceptance of the offer, the backup buyer is put in a secondary position. And it's really funny to think about this, but what the backup buyer is doing is standing there with their fingers crossed, hoping that the primary terminates. Please terminate, please terminate. Because if the primary terminates, the backup's in. If the primary closes, the backup never moves. They go about their business. The backup buyer will put earnest money in an escrow account while they're the backup buyer. They don't owe due diligence until and if they become the primary. And if they terminate for any reason upon being noticed that they're the primary, they'll get their earnest money back. So the backup buyer really isn't under any risk. They're not losing any money as the backup. They're just holding their place in line. This form only allows me to have one backup. So I can't have a backup to the backup and a backup to the backup to the backup, right? You can't have them lined out. So we have one backup. If the primary terminates for any reason, the backup moves to the primary position. As you might imagine, this form has gotten really popular in our multiple offer world that we're living in today. You get 20 offers, only one can be accepted. That means you got 19 that are rejected. One of those 19 may want to be a backup. Should come back, present a new offer, negotiate, etc. Questions on this? I'll show you in just a minute where we have all these forms, if you want to look at them. Okay. All right, so let's take 10. We come back, we're going to wrap up our form discussion and finish up unit 10. Okay. It's hard today, isn't it? It's Thursday, so it's Friday Eve. It's rainy and dreary here. I'll get your coffee, Mountain Dew, whatever your morning vice is. Okay. So let's take attendance. Woo, I hear you. I was going to say non-alcoholic beverages because, you know, I have to have this discussion with my night class. Ask them to please refrain from their after dinner cocktail until after class. And if you're curious, that comes from experience of teaching a night class where somebody chose not to refrain. We live and we learn, don't we? All right, no drinking during class. Okay. Fair? Is that fair? Especially for you guys. Okay. All right. Just kind of the last thing, I'm not going to get back in real quick, but just kind of last thing before we go look at our forms. Again, the forms that we just looked at or discussed, we're getting ready to look at, are not all inclusive. So in other words, there are other forms. We obviously, I can't go through all of them here, but know that when you meet them, or when you get into your firm, when you get into the industry, you'll meet them. We have a form for a repair request. So if the seller does agree to do any repairs, there's a form for that. Remember that one sentence in our offer to purchase and contract that says this property is being sold in its current condition. So if the seller agrees to do anything, then we have to have their commitment in writing using our repair request. I have a form that we'll see in just a second for negotiations. It's called response to buyer's offer. So basically the seller is responding to their offer. And then we have multiple forms for if it terminates, if the contract terminates. Termination with earnest money going to the seller, termination with earnest money going to the buyer, termination with earnest money in dispute. So there's several. We're not going to look at any of those termination forms in this class. We'll talk about those more in post licensing, and you'll see them when you get affiliated with your firms. But just know that there are other forms out there. The ones we talked about are the ones that you need to know. So if we look in Learn, Test, Pass, under the Unit 10 material, I got them all lumped together here for you. So under commonly used, addenda and amendments, again, this is here for you to peruse if you choose. If you get a test question, it's going to say something like, what addenda do you use if your buyer is getting an FHA loan? And then you have a choice between the FHA VA addendum, the vacation addendum, the short sale, right? You'll get the several different. So you just need a basic understanding of what each form does. Okay. One that we mentioned, our agreement to amend the contract. We said amendment was a change. So we're under contract. For whatever reason, we decide to enter into round 2 of negotiations. I have a form to change. So what are we changing? Purchase price, due diligence period. Anytime we change, yes, we can go old school and cross out on the contract, cross out the purchase price, write in the new purchase price, and have all parties sign or initial and date it. You can also go that route, but this form is just neater and cleaner. It just looks a little nicer. If you're ever amending a contract, you need to make sure that the lender and the attorney get a copy of that as well, because they got the original contract. So if you're changing any terms of that original contract, this warning is reminding us that the lender and the closing attorney need a copy as well. So it's our agreement to amend, our agreement to change the contract. Due diligence request and agreement. Again, if the seller agrees to do any repairs, we're going to list those repairs. And again, you guys, you need to be clear. Don't just say fix the electrical. Doesn't that kind of leave it open-ended? The seller could change a light bulb and say, well, I fixed it. So that you need to be specific. What is it you want the seller to repair? Spell it out. Be very clear. Once the seller signs this, they are contractually obligated to do those repairs. So keeping in mind they don't have to, But if they choose to, we need to lock them down with a form. So the due diligence request and agreement. Here's that additional provisions addendum that we talked about. And you can see here are the provisions that we talked about. So you put an expiration of offer, septic system installation or modification. Here's our rental. What information should the seller share with the buyer about the tenant, existing leases, rental agreements, outstanding tenant notices, da 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 da. Agreed upon repairs. This is where you're going to put, repair damage to sliding glass door, for example. Again, this doesn't negate the buyer being able to do inspections and investigations when we're under contract. This is the buyer saying, I'm not buying this house until that's fixed. This is something the seller should consider when we present the offer. The property has a manufactured or mobile home, or if we need to inspect a pool or a spa and it's been winterized, it's not accessible. So our additional provisions addendum. This is our negotiating tool, response to buyer's offer. The seller's just responded. The buyer's made an offer and the seller's responding using this form. They can also have their agent respond via text, email, phone call, whatever. This is just tends to be a little bit more polite. The seller has some choices here. We cannot accept this offer. We reject it. While this is not a counter offer, I'm going to put my cards on the table. Seller's going to say, this is what I would consider. If you dig it, send me another offer with these terms. Think about a lowball offer, an insultingly low offer. The seller may not want to waste their time negotiating. So they just say, look, if you're not willing to come up to these terms, we're done. If an offer's been presented and we put a highest and best, if we've called for all offers by this date and time, this is just notifying the buyer that we've put a date and time for all offers to come in. They can either keep their existing offer or they can present a new one. And then this last one, this is about the politest no I've ever seen. Thank you for your offer. We cannot accept the offer as written and hereby reject it. The only thing missing here is have a nice day. So this just is the flat out thanks, but no thanks. So that's our response to buyer's offer. The seller is responding to the offer. Here's our backup contract addendum. If the buyer wants to be in a backup position, the conditions and the terms, again, I'll let you guys look at this if you like. The last page of this, if the backup is moving to the primary, the seller has to notify them in writing. So the last page of this addenda gives the seller that verbiage we don't have to create. So the seller's notifying the buyer, the backup buyer, that they're now the primary. Here's our Owners Association disclosure addendum for use when the RPODS is not required. So this is just HOA information. What's the HOA dues? Who's responsible for what? This is pretty much the last page and a half of the RPODS. But the reason we're using this is because the RPODS isn't required, so we still need to get that information out. New construction addendum, we didn't really talk about it, but I just kept it in here because you're going to be dealing with new construction. So again, don't worry about it. Just look at it if you want to. If we're using the new construction addendum, we're attaching it to our standard offer to purchase and contract. And if we're doing that, this is on a property, a new construction property that is almost complete. There's only a small list of things for the builder left to do. Maybe they just got to put on light switch plates or something, right? It's almost complete. There's only a handful of things left to do. If there's still a lot of construction left, if we're standing on a foundation or we're still standing in studs, I have a separate offer to purchase and contract. So we'll see in just a second, I have an offer to purchase and contract for new construction. So if it's not complete, if there's still a lot to do, We have another form for that. And basically what these forms are addressing, again, is that one provision that says this property is being sold in its current condition. Because if we present that without addressing the things left to do, the builder's off the hook. They don't have to finish building, right? Because they signed an agreement that said this property is being sold in its current condition. Absolutely. If you're standing on dirt, we would use the new construction, offer to purchase and contract new construction. So which one you use depends on how far along in construction you are. Do you use the new construction addendum with standard form 2T, or do you use the separate offer to purchase and contract new construction? I got that for you as well. If you want to look at it, I'll show you in just a second. Like here, we got to spell out what's left to do, you know, light switch plates, landscaping, right? What are the very few things left to do? We got to spell those out. Here's our additional signatures addendum. Remember, our forms only allow me for 2 buyers and or 2 sellers. So if you have more than 2, this one allows for 8 more signatures. So now that gives you 10 signatures. If you need more than 10 signatures, you do as many additional signature addenda as what you need to get everybody's signatures. So we can use that to include additional signatures. Here's our vacation rental addendum. My coast and mountain people may want to take a look at this. That's that. The 2 financing forms, I'm going to skip ahead just a bit. The 2 financing forms are here in the financing section. So I got some additional addenda here as well. Here's our FHA VA financing. If the buyer's getting an FHA loan or if they're getting a VA loan, it addresses that. And then again, our short sale addendum. And we will probably look at this when we get to it, unit 14, just because I think it does a good job of explaining it. Back up in unit 10 real quick before I forget. I have an offer to purchase and contract for vacant lot and land. If you're selling a property that doesn't have a structure on it, there's a separate form for that. Again, don't need to know it, just know that another form exists. And then here's our offer to purchase and contract for new construction when there's still a lot left to do. Maybe it hasn't even started yet. Lots of forms in this industry. Remember back in my admin days, my agents would come in my office, start to ask me if there's a form for this situation. And before they'd even finish, I'd say yes, because it's safe to say there's a form for that. That's what the real estate commission will tell you. There's a form for that. And in the event that it's a truly unique situation and there's not a form for that, then we have an attorney draft something up. Questions or comments on our forms? Okay. All right, keep going in unit 10. Let's talk about submitting offers to sellers. I think we're pretty good with some of this. We've talked about, we present all offers to our sellers. We present all of them. The low ball offer, the one that's just going to make the seller mad, I still have to present that. Even if the seller says, I won't accept anything less than that, I still have a duty to present all offers to my sellers. I had a seller a couple years ago, and he said, I can't remember, I think we listed his house for like 180, something like that. And he said, you know, Julie, if I can't sell for like 165, then I'm not going to do it. I can't afford to sell. I said, great. We got an offer for 150. Even though it was less than what he said, I still had to discuss it with him. I couldn't make that decision. I called him. I said, look, I'm sending you an email with an offer. It's less than what you said. What do you want to do? He said, reject it. I said, thank you so much. Have a nice day. It was a 30-second phone conversation, but I still had to present it. I still had to discuss it with him. What if something had happened to his financial situation last night and he didn't have a chance to call me yet? And then he later found out that I rejected an offer on his behalf. He'd be pretty upset, wouldn't he? So when your seller says, I will not accept anything less than that, great. I still have a duty to present it to you. That's what my licensing board says that I have to do. My licensing board says that I need to present those offers immediately, but in no event later than 3 days. When do we present our offers to our sellers? Immediately, but in no event later than 3 days. No, okay, let's be reasonable. What if your seller says, Julie, I work Monday through Friday, 9 to 5, and I will lose my job if I take a personal phone call. So I get an offer at 3 o'clock in the afternoon. When's immediately? Am I going to try to get my seller fired? Probably not. Immediately is like a 501, right? I still follow their instructions when to communicate. I think about the only time that it's going to take you through, I hope the only time that it's going to take you 3 days to deliver an offer to a seller is if your seller's out of the country or maybe on a cruise and didn't get the Wi-Fi package. If that happens, you need to have a discussion with them before they leave. If they're unavailable, if they're not reachable, either they need to leave power of attorney to make these decisions with a family member, or they just need to take their home off the market till they get back. But I cannot sit on it and wait 14 days, 2 weeks for them to return, right? Because what's the law say? I have to deliver it immediately, but in no event later than 3 days. If they say I'm going to be totally off the grid for 5, we need to have a discussion. By the way, this conversation applies to listing agents delivering offers to their sellers. It also applies to buyer's agents delivering offers to for sale by owners. For sale by owners don't have an agent, they're unrepresented. So if your buyer's going after a FSBO, we deliver that immediately. Any questions on this? What if I have one offer in my hand? I present that offer. And before I can present it, or about the time I'm presenting it, I hear from another agent that tells me they're going to write an offer up and they'll be submitting it shortly. Should I tell my seller that we may have another offer coming? Here's the one that I have in my hand. If the one they have in their hand is perfect, the dream offer and everything that they could have asked for, we don't have to wait for the one that's coming. I only can present what I have in my hand. I let them know I'm going to get another one this afternoon, but you guys got to understand a lot can happen between now and this afternoon. But we still need to notify our sellers. Maybe they look at the offer in the hand, they say, this isn't great. What do we do? Let's wait and see what we get this afternoon. And then we can see how to respond to both. We got to keep our sellers informed.
Quick question.
Yeah.
So you said it. So we have. They say, this offer is great. We have an offer in our hands, but we know that it has not been sent yet, but we know that one is coming. We are allowed to let them know that there's one processing. Is that what you said? Do I understand that correctly?
Oh, absolutely. They deserve to know. Before I make a decision on this one, let them know what I know. I let them know what I know. Guys, here's the deal. Sellers are free to accept any offer at any time they wish. Sellers are free to accept any offer at any time. They don't have to wait for yours. They don't have to wait for you to show the property this afternoon and see if your buyers are interested. Sellers are free to accept any offer at any time. Other questions on that?
Julie, in the book, it says, under that submitting offers to seller, it says simply telephoning the offeree with the terms of an offer is not sufficient delivery.
Correct.
Okay, so can you help me with that? Because I thought we talked about ways to deliver was email.
That's what we talked about for was creating a contract.
Okay,
So now that I have an offer in my hand, I can call my seller and talk to them about it, right? We can have the discussion. I still have to email it to them. I still have to send them the actual offer. And that's what I'm saying here. I have to deliver. I highlighted the wrong thing. I have to deliver all offers. Now I can call them and say, hey guys, we got an offer. Let's talk about it. But I still have to deliver it to them.
okay, so if I'm visualizing this, if I am a listing agent and I get 8 offers today, I'm gonna call after every single offer and say, this person offered this person offered this person offered this. And then I'm gonna follow that up with 8 emails or 1 email with 8 offers.
My very next slide is multiple offers. So hang on to that
Okay.
for 1 second. Yep.
Okay,
Just to make sure I understand Ms. Lowe's question, delivery is not over the phone. It has to be physically viewed by the person.
They have to have it in their possession.
Mail, whatever, it has to be visibly seen, right?
The reason I'm calling them is because they don't know the offer like I do. So I'm going to call them and having a conversation with them, but they still have to have it. Alicia, the short and sweet of that is however long it takes the listing agent to go in MLS and update it. MLS has a rule. Tried MLS has a rule that says it's got to be done in 2 days. Don't know about other MLSs. Okay. So let's talk about multiple offers. This crazy world that we're living in today. First off, the fact that we have multiple offers is not a material fact, which means if I have multiple offers in my hands, I don't have to disclose that. Whether or not you disclose the fact that you have multiple offers is up to the seller. The seller decides if they want to disclose the fact that we have multiple offers or not. And the rule with multiple offers says that we have to deliver everything that I have in my hand all at once in no particular order. So Mendy, to your question, do I call my seller with every single offer, or does my seller just say, just wait and call me at 5 o'clock tonight and we'll discuss everything we got? You with me? If my seller says, I want to know as they come in, then I'm calling them every time. I'm sending an email every time they come in. If my seller says this is really overwhelming and I just want to wait till 5 and talk to you about everything, then that's what we do. The key to this is I present them in no particular order. I cannot favor one offer over another. I cannot say, this is the highest priced offer, this is the second, this is the third. What if I get an offer from another agent in my firm? Better yet, what if I'm presenting an offer from a buyer that I'm working with? I cannot favor one offer over another. And what a lot of listing agents are doing, guys, think about it. Be honest. It's okay. Did you get a little overwhelmed when you looked at the 15-page offer to purchase and contract? Was that a lot of information and a little overwhelming? It's okay. You can be honest. Can you imagine a seller getting 20 of those things? Look at some of y'all grabbing your head. You see what I'm saying, though? It's intimidating, right? It can be very intimidating. That's why the seller has me. So while I'm sending all 20 of those offers, this is why I'm still discussing them. One thing that's happening in this multiple offer world that we're living in that I like so much, Listing agents are like creating an Excel spreadsheet, just listing out the terms of the offer. So here's the term from offer number one, sales price, due diligence, earnest money, etc. Here's the terms of offer number two. Here's the terms of offer number three. So we're still presenting them, but we're kind of giving them the short and sweet, the main factors to focus on. Because what's 15 pages times 20 offers? Just send that to a seller and say, look this over and let me know what you decide. The seller just went, oh my God, right? So that's why they have us to help decipher through some of these offers. It's not always the highest offer that wins. Your seller has certain terms that they may seem favorable. Maybe they want a really high amount of earnest money. Maybe they want to close at a certain time. So there's certain terms that the seller may consider more favorable when they're looking at everything. So and the other thing I like about the Excel sheet, while we are still sending the offers, absolutely, I have that duty. If we're just looking at the Excel sheet, one thing not on the Excel sheet is the names of the buyers. And we don't want the seller to make a decision based on who they think the buyers are. That could be a violation of fair housing that we'll talk about in Unit 19. The seller's bottom line should care about how much, what are the terms, how strong does their loan approval letter look, their pre-approval letter look. It's not always about the most expensive offer. Y'all want to hear a true story? True story. My teammate last year was a buyer's agent, and he was a multiple offer situation. And he didn't think their offer was great. He thought their offer was good, but he didn't think it was great. But that's what his buyers were willing to do. That's what his buyers were willing to do. So he presented the offer. Listing agent called him and said, congratulations, you won. He said, wow, I'm surprised. I knew it was a decent offer, but I didn't think it was a winning offer. The reason they won, there was a note in MLS. We have a field called agent only remarks. And there was a note in agent only that says, please submit this form. And I don't know what form it was, not important. Please submit this form when presenting your offer. And he was the only one that followed simple instructions. The only one. And the seller said, it's not the most expensive offer, but for ease, we want to work with that guy. Isn't that something? He won because he followed instructions. 20 some offers. The sellers are free to accept any offer at any time. Whichever one the offer wants to accept, the seller wants to accept, they can. One thing I can't do is shop offers. Let's say I have 5 offers in my hand. I can't call buyer number 6 and say, this is what everybody else is offering. Do you want to match it? Do you want to beat it? I can't pit them against each other. I cannot share the information of their offer without their permission. And guys, remember, if you're the listing agent, presumably the seller's your client, which means all those buyers are your customer. And we still have a duty to treat them honestly and fairly. Questions? Submitting offers or multiple offers? If I didn't answer everything, please let me know.
Julie,
Yeah.
how often do you see, like, for example, you get 6 offers and maybe 2 of them, or maybe one of them is going to lead the seller to end up, like, the whole commission goes to one firm. Do you see what I'm saying?
No.
Like, you get let's say you're showing the house, you're the seller's agent, and you get an offer in and you get several offers in and none of them are like for your firm, but then you get one in. Have you ever seen anyone kind of persuade the seller
I
to,
haven't, because we shouldn't, because I can't
Right.
favor one offer over the other.
right, but
We
I just
shouldn't.
wondered if that happened.
I'm sure it does every day. You know people. I'm sure it does every day. What do you need to know to pass your test? What do you need to know to build a strong career that's going to last forever? We shouldn't favor one offer over the other.
I just can't see being able to work with a firm that would allow that.
Switch firms, you know, because the commission rule, bottom line, you get yourself in trouble. You're not going to be able to look at the commission and say, but my firm told me commission rule trumps firm policy. You know, if your BIC tells you to do something, you'd be like, commission rule doesn't allow me. You may want to consider changing firms. People do bad every day, you guys. I wish I could stand here and tell you that everybody in real estate is good and honest. And, you know, name me an industry, any industry where everybody is 100% good and honest at all times. Yeah, real estate's another one. I had a post licensing student. He's a provisional broker and he was a listing agent, and he was in a situation where one of his buyers, his buyer client, wanted to make an offer on one of his listings. So he had multiple offers, and one of those offers was from his buyer. And I said, ooh, how did you handle that? And he said, I let my broker in charge present the offers. So he removed himself from that piece of the transaction, and his buyers lost out. His buyers didn't have the best offer, but he couldn't coach his buyers. He couldn't say, well, these are what the other offers look like. I thought he handled that very well. He let his BIT communicate with the sellers and figure out which one they want to get under contract. Y'all, I'm not the ones, this is not my house. I'm not the one that can make these decisions. What we're doing is help educate the sellers about the terms of the offer. The other thing I want to say about multiple offers, if you want to counter, you can only counter one. You can't counter all 20, because what if you counter 20 and all 20 buyers come back and say, I accept? So if you have to counter, which in this market, there's not much countering going on, but countering will come back. And if you're in multiple offers, if you're not wild about all of them, then you pick the best one and counter it first. Try to work that one out first, but you can't counter multiple offers. The seller can only be under contract with one buyer.
Julie, I have a question. In
Yeah.
the example that you were just speaking about your friend having I guess a buyer that wanted to deal with one of his listings, would that be a situation in which you could do a dual
That's exactly what he was in. One buyer, one seller, same firm, right?
Okay.
That's exactly what he was. He was one agent as a dual agent in that transaction. If it had gone through, he would have been one agent as a dual agent in that transaction. Yep.
So could he have presented the offer himself if he got them to agree to do that dual agency?
Well, we had to have agreement to dual agency to ever show the property, right? So we've already agreed to dual. But with multiple offers, you can't favor one offer over another. So it's not like what he can't do is say, this is an offer from my buyer. Let's look at this one first, and then we'll look at the other offers if you want. We cannot favor one offer over the others. And that's why he chose to kind of remove himself from that piece of the transaction.
Okay, got you. And one more question on page 297. In the same handling multiple offers, that last paragraph, a broker is not required to disclose a multiple offer situation. What are they referring to right there?
The fact that multiple offers are not a material fact. It's up to my seller if we disclose that we have multiple offers.
Oh, okay. Okay, got you.
Okay. So dual agency would have already been discussed with seller. Yeah. We
So-
decided on dual agency back in the day when I signed the listing agreement.
So not disclosing multiple offers means it's not a material fact. Okay, never mind. I got it.
Worked it out, okay. I had the conversation with my sellers. Do you want to let buyers know we have multiple offers? Some buyers, when they find out there's multiple offers, they up their game. Other buyers, when they find out we have multiple offers, they say, whoa, I don't want to play that game. So that's up to the seller if we disclose that. Did I say that broker was provisional? Yeah, they were in post licensing. So they were a provisional broker.
I have a quick question, Julie.
Yeah.
And I hope I'm not too far ahead. So in regards to that, I know we're not favoring multiple offers, but I guess my question would be, would you reject all of the offers and then just counter the one? Like, how does that process work?
I wouldn't reject them just yet.
How long, like what time period do they have to reject? You know what I mean? Like,
Remember, the offeror can take back their offer at any time prior to acceptance. They can put an expiration date on it. So there is no time fine. I can call, I can counter if this doesn't work out. I've still got these other guys hitting waiting until they either reject their offer or it expires.
okay, thank you.
Yep. The offeror is free to reject their offer at any time prior to acceptance.
And Julie, not to
Yeah.
dwell on, go back to dual agency, but that example that you just gave us could create an aha for me. So that if your friend, if they had accepted the offer of the buyer, the one okay, so the BIC had stepped in and submitted the offers to the
Mhm.
seller.
Mhm.
If that one, the buyer, if it had actually went through, then the BIC would have then designated someone to be, even though, let's just say dual agency obviously was accepted in the agency agreement, then the BIC would have represented that buyer, or what would have happened at that point?
Well, it depends. The parties have to agree to designated. The firm has to offer designated. Designated is the better option for the clients, right? For the people, not for necessarily me, the one agent trying to work with both sides.
Right.
So it depends. Can we offer them designated? If
Let's
the
say,
firm
yeah.
allows it, and if they agree to it, and if you are one agent and they're designated, then you can't be designated on both sides.
Right.
So the BIC would have to decide how to proceed.
Okay. That was just a good scenario to try to kind of understand that.
Yep. You guys are coming in. I've heard the experts, I don't really know who they are, but I've heard the experts come out and say, we expect 2022 to be awfully similar to 2021. So you guys are coming in this market with low inventory. Interest rates are coming up just a little bit, but they're still not, breaching over 4.0 yet. They're still in a 3 point something. You're going to come into a market with multiple offer world, as we're calling it. We're not always going to be in this market. This pendulum is going to swing back, and we're going to be in a different market somewhere down the road. That next market is going to have its own unique set of challenges. The market after that is going to look different. It's going to have its own unique set of challenges and things to figure out. Right now, what we're dealing with is low inventory. Did I tell you guys, another one of my teammates listed a house a couple weeks ago. We were on the market for 2 days. They got 45 offers. 45 offers. One went under contract, 44 were rejected. By the way, they just closed this week. Isn't that crazy? This is welcome to the market that you're coming into. It doesn't matter what market you come into as a new agent, you're always coming into challenges. It's real estate. Other questions about multiple offers, specifically about multiple offers?
Okay, just, I'm sorry. So again, just seeing the scenario.
Is it about multiple offers?
Yes, because you could
Okay.
be like, if you're the agent and you're talking about 45 offers, you could be an agent that actually has several clients that could be
Yeah.
making offers on all those.
You could have 2 buyers that want to make an offer on your listing.
Oh, wow. That seems just,
Guys, remember, I am not looking at my buyer saying you're going to offer this much, you're going to present this much due diligence, you're going to present this much earnest money. I help coach them through. Every single buyer has a different risk tolerance. Some buyers are going to be more comfortable offering more due diligence than others. Some buyers are going to want different terms. They're all different. It's not my job to tell them what to do. It's not my job to tell them what the other guy offered. My job is to get them to do what they are comfortable doing. Maybe you'll win, maybe you won't. But if I have 2 buyers presented in the same offer, in the same listing, I need to help them get through with what they're comfortable with. It's the difference in, let's drain your savings account and go to Las Vegas this weekend, versus let's go to Sheets and get us a scratch off ticket. What is your risk tolerance? What are you willing to lose? Are you willing to lose $50,000 in due diligence? Then I'm not going to suggest you present an offer with $50,000. This is what we do. We help buyers in this market understand their risk tolerance, and everybody's risk tolerance is different. Okay. Let's see. Contract modifications and counteroffers. Counteroffer, remember, any change to a counteroffer is a rejection. Any change. I don't care how small it may seem. You get an offer for a closing date for March 31st, and your seller says, no, I need to close on March 30th. That's a counteroffer. It's only 1 day, but it's a change. Any change is a rejection, possibly a counteroffer. If you're going old school and you're countering on the paper itself, you cross out the original term, write in the new one, and everybody initials and dates it. And if you do that enough, it's going to look hard to read. So if you have lots of changes, once you come to an agreement, produce a new offer that reflects the new terms. You're going to want to keep the one that you changed, the one that you can't read anymore, because that shows your meeting of the minds. That shows your mutual assent. Document everything. Don't throw much away.
Julie, I have a question.
Yes.
When you're referring to making changes, I know you said any change is considered a counteroffer. So the form that you were saying before, I can't remember what the addendum was called, but when would you use that, and when would you actually consider it a counteroffer? It was the form that you said that it's not really a counteroffer, but they can list something at the bottom.
So it's the response to buyer's offer.
When would you use
And
that?
And that form spells it out, and it's also talked about on page 297. The seller's not countering, they're rejecting.
Okay, so for them to, so they have to reject it completely for it to be a counteroffer when that.
No,
but if that.
Nope, there's 2 different things. Either they reject it or they counter it. So, all right, let me finish this and then we'll go look at that again.
Okay.
All right. The other thing I need to say, retain all offers. If you're the listing agent and you get 45 offers, remind me again what we document. We document everything. How long do I keep all my records? I keep all records for, who remembers? I see some fingers going up. I keep everything for 3 years. So 45 offers come in, you got to keep, you can only accept one, only one goes under contract, but you got to keep all the other 44 offers. You got to document everything and keep everything for 3 years. Okay, so you get multiple offers, even though 44 of them are rejected. You keep them all. And to lead us to break, the response to buyer's offer. Thank you for your offer. We cannot accept the offer as written and hereby reject it. While this is not a counter offer, we would favorably consider the following changes. And then the seller has the opportunity to put all their cards on the table. What would they consider an acceptable offer? And then they go on to say, if the above changes are acceptable to you, please submit another offer with the changes. Understand that we are free to accept any offer at any time. It's not a, it tells us this is a rejection. This is not a counter offer. Again, think about a low ball offer. It may not be worth your time countering. The seller's up here, the buyer comes in way down here. The seller may say, I don't want to counter this. All right, then put your cards on the table and give the buyer the opportunity to come up to our terms. Questions? We get everything? Okay, let's take 10. Come back, we're going to wrap up unit 10. Okay. Back last hour. If you have any other questions about multiple offers, dual agency, anything we've covered, I'm happy to stay on the call after class and address any questions. I will keep recording. As long as we're talking about pre-licensing stuff. If you want to talk about something else, I'm going to end recording. It's only pre-licensing material only on here. I'm always happy to stay on the call. I'm always available via email or text. Okay. So let me take attendance. Cameras on, please. And keep them on. I'm starting to notice that. Everybody good? They got to stay on at all times, not just when I'm taking attendance. Okay. All right. Counter offers, multiple offers. And again, that response to buyer's offer, you don't have to use that. You can reject or counter, just text, email, whatever, just document it. It's just an option. It's just an option. The form is just an option. Furnishing copies of offers. We have a duty. We're going to learn in license law and commission rule. We have a duty to deliver all instruments to our clients and customers within 3 days. So let's first just a second talk about what an instrument is. And an instrument is just any document that relates to this transaction. So it starts with our agency agreements. Your brand new client signs an agency agreement. I have 3 days to send them an email with a PDF attachment with their signed agency agreement. Here's your signed agency agreement. I look forward to working with you. Have a nice day. Keep the sent email. Because we document what? Everything. So you send an email, keep it. Starts with the agency agreement. We go under contract. We have contract paperwork that everybody signs. That's what this is saying. I have 3 days to deliver it. And then fingers crossed on to closing. The closing paperwork, I have 3 days to send it. What we can't do is wait until the end of the transaction and send them a copy of everything. The rule says I have to deliver it within 3 days of them signing it. And really, guys, does it take 3 days to send an email and say, see the attached PDF? I mean, that should be a pretty simple thing to do. We do, thank you to the eWorld. We do now have e-programs, e-documents. We can share them via our e-programs. Again, just make sure you document that it was sent. Most e-programs will do that for you. I don't need to send them a paper copy. I don't need to mail them a copy. E-programs, I may not even need to send them a PDF, right? I can send it through a program. But bottom line, we do what our clients instruct us. So if your buyer looks at you and says, I want you to hand me a printed copy, then just hand them a printed copy, right? They're the boss. They're the ones that hired you. So just not everybody has email. Does everybody know that? Not everybody has email. If you come across a client that doesn't use email, you're going to be learning how we used to do it before e-programs. When we go under contract, buyers and sellers obviously need a copy of the signed contract. Both agents, if involved, need a copy of the signed contract. Buyers agents, soon as you go under contract, do your little happy dance, celebrate the small wins, do your little happy dance, and then you immediately send a copy of the signed contract to the lender. We've got to get the lender starting on their process right now. Buyers agents, once you send a copy of the contract to the lender, the next thing you do is you send a copy of the signed contract to the attorney. Get them on the books. We've agreed on a settlement date. Do delays happen? Yes. But we can go ahead and get it scheduled. Fingers crossed it doesn't get delayed. So buyer and seller gets a copy, both agents, if applicable, lender and attorney. And we do so within 3 days. Okay. So we're going to walk through a scenario together. And as we come to each point in the scenario, I want you to shake your head either yes or no. I want to see your guys' reaction here, yes or no. Everybody with me, looking at me? Ready to do your head one way or the other? So we're going to walk through a scenario, this magic moment in time when it goes from being an offer to a contract. And there is a very precise moment. Remember, we talked about I have to have two things. So let's see how we're doing with that. Buyer offers a purchase price of $150,000 with $250 in due diligence, $250 in earnest money, $1,500 in closing costs, and a closing date in 3 months. They want a home warranty, and of course, they want that dang refrigerator. Yes or no? Am I under contract? Am I under contract? No. We've simply submitted an offer. The seller now has 3 choices. What are the seller's 3 choices? Walk through it with me. The seller can either accept it, reject it, or counter it. Everybody good so far? Buyer's made an offer. The ball's in the seller's court. They got 3 choices. Questions so far? In this scenario, the seller counters. They say, I'm not paying closing costs. You are not getting my refrigerator. And I want to close in 6 weeks. All other terms are acceptable, which means we're good with the purchase price. We're good with due diligence. We're good with earnest money. We just got a little closer. Sellers up here, buyers down here. We just got a little closer, right? So the seller counters. Do your head one way or the other. Am I under contract? No. Now the ball is back in the buyer's court. And the buyer has 3 choices. They can accept the seller's counter, they can reject the seller's counter, or they could counter themselves. Everybody good with that? 3 choices. Are y'all dreaming about that yet? I hope so. Okay, good. So no, I'm not under contract. Seller counters, ball's in buyer's court. Buyer accepts the terms of the seller's counter and tells their agent to go for it. Buyer signs, accepts, and they tell their agent to go for it. Am I under contract? Nope, not yet. That's one step, right? That's one step to form the contract. We've signed it and we've told our agent. What's the second step? I need communication to cross the line, and just because I'm out of room. Selling agent calls the listing agent and says, you got yourself a deal. My buyers accepted your seller's offer. Communication has crossed the line. Now am I under contract? Every head should be bobbing up and down. Yes. Again, I ran out of room, so I know that was kind of easy, but you guys get the point, right? You see what we did. We presented an offer. We countered it. Our buyer signed it. And then communication crossed the line. So when does it go from being an offer to a contract? All parties agree, accept, sign, and then communication of acceptance crosses the line. What questions do I have on this? Okay. Y'all get your private chat ready. Set a private chat to me. And I want you to tell me in a private chat, A, B, C, or D. I just love it when y'all answer with question marks. Like, what does that mean? Are you asking me? Have some confidence in your answer, even if it's wrong. Dang it, have some confidence in it. Be wrong proudly. I'll give you about 30 more seconds. Thank you for the exclamation point. All right, let's see what we got here. On Sunday, a listing agent receives a written offer for $145,000 on a house listed for $154,900. Well, we're not in this market right now, are we? On Monday, the seller counters at $149,900, gives the buyers 3 days to accept. On Wednesday, the buyer rejects the counter, and upon being informed, the seller says, no, 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 I'll accept the buyer's original offer. Under these conditions, there is what? A counter offer is a rejection. And with a counter offer, there is no going back. When you counter it, it is dead on the table. The seller can't go back and say, no, 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 I changed my mind. They already rejected it. It's already dead on the table. So we got nothing. Now, let me ask you this. Could the seller present a brand new offer to the buyer with those terms? And the answer is absolutely. There's no going back. But we could revive this as the seller presented an offer with those terms. Everybody good with that? A counter offer is a rejection with a but. I'm good with all these terms, but this, this, and this. Questions? Okay. The rest of Unit 10 is alternative land conveyances. Guys, it's all green stars. So we just need a basic understanding. That's the best good news you've heard in a while. Has it been a while since we've seen a green star? Yeah. So, so the rest of it is green stars, which means we just need a basic understanding. So we're going to get through this understanding. I'm providing you with what you need to know. Alternative land conveyances. These are other methods to convey property. Poshmark. I don't know that one. So first off, we have something called an installment land contract. And with an installment land contract, the buyer is paying the seller the purchase price, but they're not doing it in one lump sum. They are doing it in installments. They're making payments to the seller. So what we're doing is we're combining the sales contract and the financing instrument. Pretty much the seller's acting like the bank. I'm going to pay you eventually, but I'm just going to do it. I'm going to break it down over a period of time. With an installment land contract, the seller keeps the title until the last payment is made. The seller keeps the legal title. The buyer gets to live there. They get to possess the property. They could profit from the property. They could have a tenant. They can do whatever they want to. But the seller keeps the legal title until the last payment is made. Next week, when we get into financing, we're going to talk about seller financing. The difference in an installment land contract and seller financing is when the deed changes hands. In an installment land contract, the buyer doesn't get the deed until they make the last payment. As we will learn next week in seller financing, the buyer gets the deed at closing. We don't have a pre-printed form for an installment land contract. So if your parties want to do an installment land contract, we need to call an attorney to draft something up. I don't have a form for this. If you're the listing agent and you get an offer to do an installment land contract, do you have to present that to your sellers? I see heads going up and down, and the answer is yes. Why? Because I present all offers to my sellers. And an offer to do an installment land contract is an offer. So buyer agrees to purchase property, pay the seller the sum of $105,000 in the following manner. I'm going to give you $5,000 at the execution of this contract. The balance of $100,000 together with the interest rate of 12% each will be paid in full. Said principal and interest shall be in 240 installments of not less than X amount per month, beginning on this day of March 2019. So for the next 240 months, the buyer is going to pay the seller $1,101.09. And after the 240th payment has been made, then the buyer gets the deed. There's pluses and minuses. Let's talk about seller advantages and disadvantages. One of the advantages to the seller, they still own the property. So they might get a tax break. They might have tax benefits. The deed's still in their name. This could be something good for the seller if they're dealing with a hard to sell property. What if it's a property that needs lots and lots and lots and lots and lots of repairs? It takes a very special, a very unique buyer. They got to have skill. They got to know what they're doing with a hammer for the most part, right? Or have the money to have those repairs made. So this might make a hard to sell property more desirable. The big advantage to the seller, they keep that legal title until the last payment's made. We'll talk about what happens if the buyer defaults in just a second. The big disadvantage to the seller is low down payment. They're going to get their money, but they're going to get it over the course of X amount of time. They're not getting it in one lump sum. So if the seller needs all their money right now, they may not be able to do this. This may not be an option for them. Advantages and disadvantages to the buyer. This could be a good option for them if they have poor credit. Maybe a lender won't give them a loan, but the seller is willing to work with them. It's how the seller can get away with charging 12% interest, right? They got something the buyer wants, for example. The buyer's living on the property. They're possessing the property. They too may be able to take advantage of certain tax benefits. Tell them to call their accountant, unless you are an accountant. The biggest disadvantage to the buyer is probably the biggest advantage to the seller. And that is in the event of the buyer default. How long does the buyer have to default? Is it 1 month? Is it 3 months? That's all negotiable. But with the buyer default, the seller calls, they have to give them 30 days to call the entire note due. And if the buyer can't come up with the full amount due, game's over. They're out. The seller still has the legal title. The seller keeps any money they've received up until this point, and the buyer has to move out. And if the buyer's not willing to go, then the seller goes through the eviction process, that of a landlord, that of which we will talk about in Unit 11. So in the event of the buyer default, the seller says, you've got 30 days to pay me everything you owe me. And if you can't come up with that money, you're done, you're out. Another big disadvantage to the buyer, they don't own the property yet. They don't have legal title yet, so they can't use the property as collateral. Questions on installment land contracts? Another alternative land conveyance. You guys remember back in Unit 9, we talked about bilateral contracts and we talked about unilateral contracts. And bilateral contract is a two-way street. That's what we use the majority of the time. And we said in real estate, we have one unilateral contract. And our example of a unilateral contract is an option to purchase. It's unilateral because only one promise is made. The buyer has not promised to buy. The buyer has simply requested for the option to decide if they want to buy. The buyer has not made any promises. The only promise made is by the seller, who promises not to sell their property to anybody else during this option time. I'll give you 5 weeks to decide if you want to buy. At the end of 5 weeks, you either buy or you don't. During that 5 weeks, I promise I don't sell my house to anybody else, my property to anybody else. All the terms of the agreement are, all the terms of the contract, excuse me, if the buyer decides to buy, are agreed upon up front. If I buy, I'll do so at this purchase price with these terms. So all that's decided up front. Think of this, I mean, we can do this in residential, but I think where we're more apt to see this, more likely to see this, is commercial. Maybe you're thinking about buying a big warehouse or a big factory. You wanted time to decide. You want your structural engineer to come out and look at the building. You want your general contractor to come out. So you offer an option. What in the world would make a seller agree to do this? What in the world would make a seller not sell? And the answer is there's usually a very healthy option fee involved. I'll give you $10,000 if you promise me you won't sell your house for 5 weeks. Where do I sign, right? Make the check out to Julie Campbell. So with an option, there are 2 forms of consideration. The agreed upon purchase price, again, we agree to all the terms before we enter into the option. And then there's an option fee. If at the end of the option period, the buyer decides to buy, that option fee will be credited back to them. If they don't buy, they lose it. Kind of sounds like the due diligence period, doesn't it? The difference in the contract in due diligence, the buyers agreed to buy. Here, they have not yet. They have a time, they bought time to decide if they want to buy. What if you work for big corporate USA and they send you down to Wilmington to find them a new location? They're going to open a second store or second plant. And you get down to Wilmington and you see 2 properties that could be really good, but corporate USA needs time to investigate the properties. That might be an example. We would put an option on both of them. At the end of the option period, we buy one and we don't buy one. Remember, we've already agreed to the terms before we entered into the option. The buyer can always ask the seller to do repairs or to renegotiate the purchase price. We can always ask. The seller's under no obligation because they've already agreed to these terms. Question came in, should this be recorded? You bet, because we got to protect the buyer from the shady seller, right? Just because the seller looks at you and says, I promise I won't sell it to anybody else. We got to keep them at their word, and how we keep them at their word is we record this. So in the event they sell it to somebody else and the buyer's attorney does a title search, they're going to find this and it's going to throw a flag up for them. Once again, I don't have a form, a pre-printed form. So if you have the opportunity to do an option, you're calling an attorney, the attorney knows to record it. If you're a listing agent and you get an offer to do an option to purchase, do you have to present that to your seller? Yep, because we present what I just gave it to you. There you go, because we present all offers. And an offer to do an option to purchase is an offer. Questions? Option to purchase. Another alternative we have, first off, I have something called a preemptive right. And I got a couple different types of preemptive rights. So listen first and then you can write. A preemptive right is a contractual right. Somebody has a contractual right to purchase your property first. We have entered into a contract. Maybe I don't want to sell just yet, but when I am ready to sell, you're first up. That's a preemptive right. You have the right to buy before anybody else. And we have two types of preemptive rights. First off, we have the right of first refusal. The owner promises the contracting party that if I'm ever presented with an offer, if I ever get a bona fide offer in my hand, I'm contractually obligated to come to you first, give you the opportunity to match that offer. If you want to, you buy it. If you don't, the third party presented me the offer. Maybe you live in a lot that next door has a vacant corner lot. And maybe you don't want to buy that vacant corner lot, but maybe you don't want Dollar General to buy it either. So if you have this right of first refusal, Dollar General comes to the owner of the vacant corner lot, says, hey, here's an offer. That owner is contractually obligated to come to you first and give you the opportunity to match or beat that offer. Right of first refusal. The other preemptive right is the right of first opportunity to purchase. Seller doesn't want to sell yet, but when you are ready to sell, you're contractually obligated to come to me. Maybe you have an offer in your hand, maybe you don't, doesn't matter. Before you make it available to anybody else, you are contractually obligated to sell it to me, try to sell it to offer, there we go, offer to sell it to me first. Think about a tenant landlord situation. Maybe the landlord doesn't want to sell just yet. Maybe they're enjoying reaping the rent, collecting the rent every month. But the tenant could have a right of first opportunity to purchase, that if that landlord ever does decide to sell, they're contractually obligated to go to them first. No pre-printed forms. Call an attorney. The difference in the two, again, right of first refusal, you have the opportunity to match a bona fide offer. Right of first opportunity to purchase. If I ever sell somewhere down the road, I gotta offer it to you first. Before I offer it to anybody else, I gotta offer it to you first. Alternative land conveyances. If you didn't hear anything else, here, call your attorney or their attorney. Questions? Do y'all want to feel like you've accomplished something today? Key terms for Unit 10, back on page 269, key point review on 302. Student quiz 304 to 307. I might have mentioned units 7, 8, 9, and 10 are heavily tested units. 7, 8, 9, and 10. I sat down and counted it up one time because I'm kind of a nerd like that. I sat down and counted up one time. 40% of your exam comes from units 7, 8, 9, and 10. Agency and contracts. What are you dealing with every day in real estate? Agency and contracts. My exam, they don't let me see the state exam. I'm not privy to that, but they will be heavily tested. You bet. Yeah, they don't let me see that. But never fear, what's heavily tested on my exam will also be heavily tested on your state exam. Guys, here's the deal. We are almost done. I got one more thing to say. I'm going to try really hard to Kahoot today. I'm going to switch around. Anyway, we are almost, I consider unit 10 the halfway point. So congratulations, we've made it halfway. The good news. The other news is we still got half the material left to cover. So we keep going, but I need you guys going back and spending time with 7, 8, 9, and 10. Please, please do not put 7, 8, 9, and 10 down until the day before our exam. Please. You got to keep going back and reviewing it and refreshing it and seeing it and spending time with it. Because remember, your homework is always to cover where we've been and look ahead at where we're going. Because we keep going. I got one more thing in 10 I want to talk about, but I'm going to wait and talk about that when we come together next week. So it might be a little good refresher for us. But what I want to do in our last 30 minutes together is Kahoot. I do want a Kahoot. We'll Kahoot, and then we'll talk about what next week is going to look like, because I do want you guys looking ahead. So you're either going to the website, kahoot.it, you're getting the app. If you're doing the website or the app, you're using the game pin, 228-7668, or you're just getting the QR code. This Kahoot is on units 9 and 10. This is our contract Kahoot. Kahooting's fun. I don't know, I'm not wild about this music, but that's why you can barely hear it. You guys don't even hear it at all? It's just me that it's annoying? Okay. I don't want to break your concentration. I didn't change anything. I don't know why I can't turn it up. You're not missing much, trust me. Kahoot music's never going to make it to the top 40, right?
I need all the concentration help I can get.
Give you just a few more seconds if you want to get in. Kahoot for 9 and 10, contract Kahoot. You want to play. If you don't want to log on, that's fine. Just play in your mind. See how you're doing. Good way to gauge yourself. And if you're not passing Kahoot questions, you may want to spend time in units 9 and 10. Did I shut it up? I don't hear my music anymore. Anybody in that wants to play this time? They're good? All right. Units 9 and 10. Question number 1. A void contract is one that is ten seconds. Good job, guys. It's not legally enforceable. It's void because it's missing one of the essential elements. Remember, the judge is going to look for the essential elements to determine the validity of a contract. So if it's void, it was never a contract to begin with because you're missing one of the essential elements. Questions on this one? So see how we did. Who's the quickest? Meg answered the fastest, followed by Star and James, Tim and Anu. Question number 2. The essential elements of any type of contract include all of the following except. Ten seconds. Essential elements of any type of include all the following except agency disclosure. Agency disclosure is not a contract. It in no way is a contract. It is our working with real estate agent. What are you doing with agency disclosure? You're letting the party know who you represent. And most importantly, you're letting them know, don't you tell me anything confidential until you decide to hire me. The essential elements of a contract, offer and acceptance, that's our mutual assent, our meeting of the mind. An offer has to be made, it has to be considered, and it has to eventually be accepted. We got to have competent parties, legal consideration. We also have to have legality of object. Essential elements of a valid contract. Questions on this?
I was thinking that offer and acceptance would be once the contract is agreed upon, but not necessarily to write the contract.
Where does it say anything about writing the contract? So in order to have a contract, valid contract, you have to have mutual assent. You have to have meeting of the minds. So to form a contract, an offer is made and is eventually accepted.
Okay, thanks.
Yep. So no, you mark that you've received the agency disclosure on the working with real estate agent. The only thing the contract says is that I've received this. You don't check anything, you don't mark anything. It just says I've received it. And remember, this is any type of contract. This isn't specific to agency agreements, to offer to purchase and contract. This is just contract law. So with any contract, no contract, agency disclosure, it's a separate thing. Agency disclosure is not a contract. It does not create agency. Questions on this one? Essential elements of a contract back in Unit 9. So we got Brooklyn, Tosh, Bob, Christina, and Valen. Tara is our highest climber. She's up 13 places this round. Question number 3, the law requiring real estate contracts to be in writing to be enforceable is the Seven seconds. Has to be in writing to be enforceable. Is a statute of frauds. What's Connor tell us? And 3 of you are telling me hit the wrong button, so I'm guessing you hit Connor. What's Connor do? What's Connor do for us? Connor says that we have to record to be enforceable. Connor says we record to be enforceable. Statute of frauds says we put it in writing to be enforceable. Tricky, tricky. Flashcards. You got to know the difference between these 4. Questions on this one? Connor says record. I just heard somebody in my house, but my husband came home for lunch, so it's all good. And he had a bag of food, so that's cool too. All right, any questions on this one? So we got Tosh, Bob, Christina, Valen, and Matt. Meg's on fire, 3 in a row. And as a reminder, once you answer Kahoot, you can't change your mind. So be careful to hit the wrong button. Question number 4, if the seller makes a counter offer, the prospective buyer is $10 seconds. Seller makes a counter offer, prospective buyer is relieved from all offer obligations. Counter offer, roles reversed. The seller's now met the offer or making the offer to the buyer who's the offeree. As the offeree, what are their 3 choices? Accept it, reject it, or counter it. So they're relieved of all offer obligations. They make the offer, the seller counters, buyer can reject it. Questions on this one? Remember, we can't force anybody into a contract. They have to enter into a contract voluntarily. Okay. Tosh staying up top. Christina and Bob are tagging back and forth. Valen and Matt didn't budge either. So these 5 look like the ones that we need a competition for this game. Amin is our highest climber up this round. He's up 8 places. I like watching y'all's competitiveness come out of during Kahoot. A lot of people say real estate agents are just competitive in nature. So release your competitiveness now. Let it play out in Kahoot. Question number 5. To rescind a contract. One is $10 seconds. If you're rescinding a contract, you are canceling it. You're taking it back. What are you doing if you're changing it? What's that word we used? Yep, I see your mouse go. You're amending it. If you're amending it, you're changing it. If you're rescinding it, you're taking it back. Did you put down any deposits? You'll get that money back. 5 days to rescind a timeshare, 7 days to rescind a brand new condominium construction. Questions on this one? That didn't budge, did it? All right. Matt's on fire this round. This is going to get interesting the next couple questions. Let's see what we got. To assign a contract for the sale of real property is to, what if you're doing if you're assigning it? $10 seconds. If you're assigning it, you're transferring your rights and responsibilities. With an assignment, all the terms stay the same. It's just the name of one of the parties that changes. So you're assigning, you're transferring your rights and responsibilities to somebody else. Questions on this one? assignment, flashcards, vocab words. Let's see, Bob, Fallon, and Mendy, Tash and Christina, 3 of you are on fire this round. Answer streak of 3 in a row. Here we go. Last one. Let's see what we got. In the event of seller breach, the buyer can sue the seller and force them to sell. This is called ten seconds. Seller breach, buyer sues, force them to sell. Specific performance. When you see specific performance, see the word perform. If the buyer sues for specific performance, they're making the seller perform as promised. They're making the seller sell. Our consequential damages are money damages. So you could sue for consequential damages, but you're suing for money. Questions on specific performance. All right, y'all ready? Big reveal. Dramatic conclusion. Our 3rd place winner is Mendy. Good job. 2nd place is Valen. And our 1st place is Bob. Runners up are Tosh and Christina. Questions on this Kahoot? Guys, please remember, a couple of these questions alluded to this, so I want to make sure that we're good. Please remember, I can't make anybody do anything. If my seller doesn't want to sell, I can't make them sell. If my buyer doesn't want to buy, I can't make them buy. Okay, they have to enter into this voluntarily. Was it you guys I told about this, or was it my other class? My team leader got a call from another agent this week. Did I tell you guys about this, or was this somebody else? And the other agent, she didn't know her, but my team leader's highly regarded in this area. She's been in it for like 35 years, so people know her. And somebody else, another agent, had a problem, had a situation, and she said, "Oh, I don't know. Why don't you call my team leader?" So she called and said, "I was told to call you." And she called my team leader and said, "I have a buyer that says that they don't want to close. How do I make them buy?" And the answer is, you can't. You can't. What are you going to do? Hog tie them? Put them in your trunk, drive them to the attorney's office, put the pen in their hand and force them to sign? You can't make them buy. True story. A couple years ago, I had buyers call me 3 hours before closing and say, "Julie, we're not coming today." And I said, "Oh no, I hope everything's okay. When do you want me to reschedule closing?" And they said, "Let me try this another way. We are not buying this house." I said, oh. So it took me a minute to process. I said, "Now you guys know you're in breach. You're going to lose your due diligence. You're going to lose your earnest money, right?" And they said, "We're fine. We don't want this house." Are you sure? Are you really, really sure? I couldn't make them do it. Called the listing agent, called the attorney, said, "Yep, we're not coming today." Had a liquid lunch that day because I really didn't know what else to do at that point. The next day we got back out, showed them more property, found them another house. They got an uneasy feeling. They decided they didn't want to buy that house. The only thing I could do was tell them their repercussions of terminating, tell them that they were in breach, Tell them this was what happened. I've heard of deals falling apart before on the closing table. So what I say to you, don't you spend that commission money until it's in your hand. Don't you spend it until you got it. And you don't get it until it's a done deal, until that brand new deed is recorded. Questions or comments? So I know we're a little bit early, but I don't want to get anything started today and not be able to finish. But before you go, hang on. Next week, I got a few more things to talk about in Unit 10, not really testable stuff, but just kind of make you think a little bit. You're welcome to look ahead at it. So give me about 5 more minutes and we'll officially be done with Unit 10. We're going to talk about the process for you applying for your state exam. So now that we are halfway through, we can talk about that process. So we'll discuss how you apply for your state exam, what your state exam is going to look like. And when we're done with that, we're going to get started on our financing units. So we're going to get started on 14 and 15. I'm telling you guys right now, a lot of people struggle with financing because I'm almost removing you from real estate school and I'm putting you in lender school. I'm requiring you to wear a different hat. So it's a whole new jargon, a whole new vocabulary. With financing comes math. Be prepared to do lots of math next week. Please look ahead. Please look ahead at 14 and 15 so you can expose yourself to this stuff before we talk about it on Tuesday. Questions, comments, concerns? Okay. I'll hang around and ask questions if anybody has any. Otherwise, you guys have a great weekend. Stay safe. Find something fun to do. And I'll see you guys Tuesday morning. Thank you. Have a good weekend.
Hey, Julie,
Hey,
I have a math question, if that's okay.
sure,
Kind of goes back. I've been trying to figure it out.
sure. What you got?
Back when we were figuring out commissions,
Mhm.
and you would break it down, listing and listing agent, listing firm, and selling firm, correct?
Mhm.
And then you break it down again to the agents who get whatever. We had one question where you take some of the information that you have down at the bottom and you work the problem backwards to figure out the sales price.
Correct.
I cannot do that. I just cannot do that.
So sure you can.
Well, I was going to ask if you knew of anywhere in the book that I could go to that might, all that. Like, I got it going down, but I struggle backwards.
The steps you take going down from total commission down to agent, for example, the steps you take going down are to multiply.
Mhm.
The steps you take going up, if they give you the selling agent and they ask for commission, when you're working up the commission tree, you divide.
I don't know what to divide into what.
Okay, so let's look. You got your book in front of you?
I do.
Let's look on page 251. Number 28.
Yeah. Doozy.
So using our commission, our commission map as a guide. First, we just read the problem, right? Listing agent receives $42.8750 as her portion of the commission earned on the sale of her listing. She receives 70% of the commission retained by the listing firm. Firm split the 5% with the listing commission equally in the selling firm. What was the sales price of the property? So they give me the listing agent's commission. They tell me how much the listing agent's going to receive, and I got to work up to the sales price, right?
Right.
Remember the basic, remember T-bar 101.
Yeah.
The smaller number goes on top, bigger number goes on bottom. Percentage always goes on the bottom right, always on the bottom right.
Okay.
So the first step is to work my way from the listing agent's commission to the side. So the problem tells me the listing agent received 42,807, whatever, $87, there we go, and 50 cents. She receives a 70% commission split. So the first step, the first thing we need to decide is how much does the listing side get? And that back fourth line means divide. So we take 42,8750, divide it by 70%, which means the listing side collected $6,125. So that's the first step. I've started from the agent and I figured out the side. How much did the side get?
Right.
Now I got to go up one more tier. Again, I get to use 2 T-bars. The side commission, 61,125. The firm split the listing. The firm split the 5% commission with the listing side. So if they split it 5%, that means the listing side got 2.5% and the selling side got 2.5%. You with me?
Yeah.
They split it. So 2.5% is their side. Take 6125 divided by 2.5%, and we get a sales price of $245,000.
Okay.
So the map, this is why I like the map. So you can see, in order to get the sales price, I first have to know the side. In order to know the side, I first have to know the listing agent's information. So you can kind of see the steps to work up. What's the information that helps me determine the listing agent's commission? Well, I need to know what the agent received and I need to know their split. And once I know that, then I need to know what the side collected. And that gives me the sales price.
Okay.
Is that?
I feel like I just need to do more than the one. And that's the only one that I could find to work on. And I've worked the problem like 4 times. So I know how
Okay.
to do it. You know,
Let
I
me
know how
see
to
if I
do that
can't find,
one, number
Okay.
28.
let me see if I can't find some others for you. I'll look and see if I can't find some others for you to practice.
Hey, Julie.
Yeah.
So like I have that problem. Sometimes I get it, sometimes I don't. And the things that the resources that we have only give you limited questions to work out. It's like, is there anywhere
Examples.
we can go that
I
gives?
told you guys,
more
if you want more
questions?
practice, just reach out to me. All you got to do is let me know. So if you need more help, I'm here. So I got commission, I
just need some more problems.
all you got to do is let me know. So Cassandra and Dawn. Okay.
Thank you.
Thank you.
Other questions? Okay. You guys have a good weekend. Let me know if I can help. That's why I'm here. Shanti, you there?